would have put it in there.
Well, good morning and welcome to the 2019 Law School Assembly of the State Bar. We're very happy to have such wonderful representation, especially during a busy time of year for the law schools. This year at the State Bar, we have introduced a new way to engage with the law schools. We want to hear from you, we want to hear what you're thinking, and we want to share what we are doing as well. This assembly, if you've been to a law school assembly before, normally each of us talk about what we've been working on and what we think you'll want to know, and that will still be woven into this presentation today. But we turn the mic up?
Yeah, hard to hear you, Natalie.
Tom, are you able to help me turn up the mic? And here, should we try this one? Okay, how's that, better?
Yeah.
It's better? Okay, great. So now you can actually hear that I'm welcoming you here to the State Bar for the Law School Assembly. So thank you for joining us as a busy time of year. We are eager to hear from you, your priorities at your school, and what you think about the things that we are doing. This Law School Assembly agenda is a rich agenda. We will be busy today, that we will have a full lunch break from noon to 1. We hope you'll enjoy talking about what we've learned so far. But this really is a product of a number of different groups. This agenda started with staff. It was also shared with the Committee of Bar Examiners, as well as with 2 other new groups. The first of these is our Law School Council, which is a council composed of 7 ABA deans and administrators. This council was raised starting this past month and will be an ongoing council. So they've reviewed and helped to create this agenda as it is. You can apply to be on this council at a point in the future. We will be taking applications every year in February for future terms. We also have a committee on State Bar accredited and registered schools, and this is the first time that we have official representation for registered schools on a State Bar body. The CS Bars is the affectionate name for the body, and they have also reviewed and given their input as to this agenda, and we thank CS Bars for their help in putting this together. The first topic that we'll be talking about is the California Attorney Practice Analysis Study, and I have here Amy Nunez, the director of our Office of Admissions, as well as Dean Stephen Perullo, who is one of the deans who is on the CAPA working group, to get this going.
So good morning, everyone. I want to thank everybody for joining us here today. And to start, we did this at the last law school assembly, which I think is helpful. I think it's a good idea for us to put faces to names. And so with that, I'd like to introduce you to the admissions staff. So Natalie already introduced me. I'm the director of the Office of Admissions. Back in the middle there, we have Mark Torres-Gill. He is the assistant director of the Office of Admissions. We also have Tara Clark there in the back. She is the program manager for moral character. And sitting next to her is Lisa Cummins. She is the program manager for examinations. We also have Christina Dole, who is the assistant working on examinations, specifically in grading. On the phone, we have Tammy Campbell, who you will also meet tomorrow if you partake on the webcast of the Los Angeles event. She is the director or the program manager of operations and management in Los Angeles. We also have our chief of programs here, Donna Hershkowitz. And our executive director, Leah Wilson, is also here. So thank you. Dusty Overpeck. How could we forget Dusty Overpeck? This is our general counsel who works with us, and you've probably met multiple times. Great. Thank you. So as Natalie's pointed out, an important change to our law school assembly this year has been the fact that we are soliciting for topic areas that are salient to the law schools, and we've done that through CS Bars and also through the Law School Council. But if anything else comes to mind, please feel free to contact us to share those. Last year we focused on admissions functions, and this year we have a lot of relevant topics that of ongoing activities and initiatives here at the State Bar. So the first that we're going to talk about is CAPA. Some of you might recall that last year I presented on the multiple bar exams that have been conducted by the State Bar or were ongoing at the time. And I'm not going to get into those too much, but I just want to highlight what we discussed. The first was the recent performance changes on the California bar exam, which looked at the characteristics of students that took the bar exam and looked at pass rates to look at potential explanatory factors that are impacting pass rates. The next that I discussed at that last year's meeting was the standard setting study that focused on the analysis of the appropriate pass line or the cut score for the general bar exam. I also talked about the content validation study that examines the overlap between what's measured on the exam and what's a critical knowledge required for entry-level attorneys. The last study that was conducted and released in December of 2018 was a second component of the bar exam performance study, and this combined characteristics, student characteristics, and specifically their student performance, student characteristics, law credentials, basically, in relationship to their performance on the bar exam. Again, that study was released in December 2018. All of these studies raise many questions which the State Bar is responding to and creating the appropriate dialogue for. And this study that we're about to talk about, the CAPA, is a significant study that's going to help synthesize the body of knowledge on attorney practice and build on what we've collected as a result of these studies. So the deans today are going to present on the California attorney practice analysis to explain what that research is attempting to address. And for deans overall, I think the questions that it raises has been what's happening or what's going to happen to the cut score, questions about how the State Bar can modify the bar exam to better reflect what a newly admitted attorney should know. Some of this will be addressed through the CAPA, and what we can change. I know that's been another question. What can we change about the bar exam to ensure that it's testing what it should? And this study attempts to do that. So again, the study is going to require time and focus. And today you're going to hear about the specific components related to this study. So the first is that this study, you need to know, has been funded through a grant by Access Lex Institute. And it's, again, going to collect information on how attorneys use their knowledge and skills to perform routine tasks. And those are going to set the foundation to revisit again the bar exam pass line, as well as the content, because it can spell out any modifications or potential modifications on the bar exam format. There are 4 components to the study itself. So the first is a panel of practicing attorneys are going to assist in defining the classification of knowledge, domains, and skills as a basis for creating a practice analysis survey. Dean Ferrulo is going to give more description about that task as he participated in it and what that entailed. The second component is a survey that will be disseminated to all California licensed attorneys. It's going to collect data on attorney practices in terms of their knowledge and the skills required to perform their tasks. The third component is a detailed data collection gathering, and there are 2 components to that. First is a one-time survey response, and the second is a relatively new approach called experience sampling method, in which participants are going to provide multiple responses, for example, maybe 2 or 3 times a day, at randomly selected moments to answer questions about the task that they're currently performing and its associated attributes. Lastly, once all that data is gathered, a focus group of practicing attorneys are going to provide feedback and validation to help synthesize the survey findings. So another piece, oops, I went the wrong way. Another piece of the CAPA that everyone should know about is a working group has been established that's going to provide guidance and feedback throughout the data collection process. And this is a timeline. So as you can see here, this working group first met in January of this year. We are scheduled to complete this project by December of 2019. And as I mentioned already, the first component has been completed. And with that, I'm going to hand it over to Dean Perullo to describe the first initial phase of the project.
Thank you. Is this working? Thanks. Maybe a little bit of context here, right? Which I think is important. Of course, this is in the context of the decline in bar passage rates, both nationally, and in California, and questions have been raised about that, the validity and reliability of the bar exam, its relevance to practice in the 21st century, and its impact on access to and affordability of legal education, particularly on diversity. And these are issues that are going at the national level. The NCB is doing a study of the bar exam, and so CAPA is in that context. And I don't think we should go back on the debate about the pass line, but I think what is if we go back, is that basically what the Supreme Court has asked for is basically that the state bar identify and explore all issues affecting the California bar exam rates. And there were these studies that went on a couple of years ago that were referenced. Okay, and one of the issues that came with those studies is that those studies were based on a 2012 national job analysis. And the view was that a new job analysis was needed. What do lawyers in California do, and what skills and knowledge should they have is a way of informing what a bar exam ought to look like. So that's where this study fits in. I'm involved in this study both as a member. I've been involved both as a member of the working group as well as the practice analysis panel that met in March and came up with these domains. So I'm going to come back to those in just a minute, but let me just give you a perspective because that I have, and Jackie Gardenia and I are the two deans that are on both of these groups. This study, I think, is going to be valuable and telling us what knowledge and skills should be tested on the bar exam. And to what extent the bar exam as it currently is structured in terms of form and content is relevant to the practice and experience of current lawyers. I do not think that this exam is going to tell us anything about what the cut score should be and address that issue. And I just put that on the table because that is, in my view, the most serious issue right now. This is not going to get to that. But I'm involved in this process because I'm hoping that this will help us move forward. And I think what I want to say is my concern is, and I'll put this up front, the process that this CAPA study is leading to, I think is going to be a very long process. You've seen the timeline. The study will be done at the end of 2019, and I think that Ron and his team and others are doing a great job moving this forward in a very, very constructive and expeditious way. I feel really good about that process. I think we will be on time to get this study done at the end of 2019. But in terms of where that might lead, I think that if this is going to have an impact in the future, we're probably talking about a bar exam that's 5 to 7 years out. If you really think about the process of how long it would take to do the analysis, to think about what the design might look like, to go through the approval process, the 2-year launch period. We're talking about a long-term process about what a future bar exam ought to look like. I think that is a process worth doing. And I think that all of us as deans should be involved in that process and support that process of the state bar. I think it's a separate issue of what we should do in the interim about the bar exam cut score and about things like reciprocity and portability. Those are other issues. Okay, so I'm not naive to think that somehow this is going to give, I think anybody who thinks it's going to give a magic answer to what the cut score should be in a short period of time is not living in a world of reality. But I don't think that in any way devalues the importance of this process to all of us here in the state of California and as lawyers. Okay? So the first thing that we've been working on is a framework. The question is, what knowledge and skills are important to lawyers and what should they be tested on is for minimum competence. And so, it's been really interesting. There's been this working group, and then there's been this panel. And if I could just cut to the chase, the working group, which is broadly representative and has several meetings, came up with a framework, both of the skills and of the knowledge. And then the panel met for 3 days in March and sort of did the same thing. Interestingly, there's general getting to an agreement about the skills that lawyers need to have was relatively easy. The two groups pretty much came along with the same framework. These are the skills. These are the performance domains. Performance domains equal skills that lawyers need to have. And so basically this framework for this analysis is based on these four different skills, okay? Establishing and maintaining, sort of as chronologically, right? The relationship between lawyers and their clients. Establishing and maintaining relationships, just with clients as well as with others, practice management, administration, factual and legal analysis, and then resolution, whether it be litigation, arbitration, negotiation, or things like that. So those are the performance skills, the performance domains, and then there are, and so this is the framework for this analysis that's being done. If we could move to the next slide. The bigger challenge has been the content domains in terms of the areas of knowledge. Okay, and this has been a really interesting iterative process. The working group, when it met back in February, pretty much thought the right place to start was with the current subjects tested on the bar exam. And basically worked from those subjects, okay, and thought, well, maybe something like remedies shouldn't be a separate subject, and maybe we ought to broaden it. But basically, what that group came up with was a set of knowledge areas, or content domains, that were pretty much based on the current subjects with some changes based on the bar exam. The working group, actually the panel, went in March, took a very different approach and came up with 18 content domains or knowledge domains. Now, one of the we constantly were talking about was what the difference between the content domains, the knowledge domains, and areas of practice. Okay, because this is, and you might have some questions about, but this was basically the 18 areas that came up. Now, whenever I look at this, whenever I open this up and think about this again, I said, oh my God, does this mean that somehow we're thinking about a bar exam that's going to test 18 subjects instead of the current subjects who are already too many? And the answer is no. This is really an attempt to come up with the areas of skill, the areas of knowledge to ask lawyers about. It's not prejudging what might or might not be on an exam. Okay, so those are the performance domains, and those are the performance domains or skills. These are the content domains or knowledge. Next slide. Okay, so on this, the sampling strategy, I would really defer to Ron P. to talk about these in terms of the different types of surveys that are going to be done. Should we go into those a little bit, or would you like to do that, Amy?
Well, I'm not sure if you want to talk a little bit about the three different sampling or survey methodologies that are going through this project.
For our own study, it involves two separate survey methodology. One is the traditional survey. That's been the method used in most of the job analysis study, whether it's attorney, architecture, or all of the other typical kind of a job analysis, which is sending out a survey to a sample of practitioners and then going down a long list of questions related to skills and knowledge domains and ask them to rate the importance, criticality, frequency, and any of the relevant ratings to get a sense from the results of the survey about the relative importance of those knowledge and the skills. So that's part of the survey. But in addition to that, we thought that traditional survey, it's very useful, reliable, but there are some issues we might want to explore to see whether a different methodology would give us different information. So we pushed the consultant to use what we call the experience sampling method. That method has never been used in any job analysis. It involves sending out notifications to participants at random moments throughout the day during a survey period. It's probably going to cover 1 to 2 weeks period. So anyone who participated in the survey will get 1 to 2 notifications. And at the time they get the notification or later on found out that they have a survey, they'll fill out the survey answering just a couple of questions. One is, what are you doing at this moment? Followed by the kinds of knowledge required to perform the task. And then related to both the task and knowledge, we ask the same kind of a rating question in terms of the importance, criticality, and the working group have come to a consensus about a long list of the ratings, and the third one we're going to use is performance expectation. That is, at what point in your legal career you are expected to have the knowledge in order to perform the task that at the time of getting the notice you just happen to be doing. So this is a more immediate kind of response related to the work that they are actually doing. It'll give us very accurate information rather than recalling on the kind of frequencies that they think the different tasks of knowledge use. And we're going to use the results from the 2 surveys to see whether there are differences or they converge to some similar results. The third survey we're talking about is NCB just happened to be on the same timeline of creating a survey of their own, and we have to coordinate not only in terms of the mailing list we're going to share with them, but also in terms of the questions, how we phrase the question, identification of the skills, knowledge domains. So ideally, we can also compare the results of our survey from the two studies with theirs at a national level. So in order to achieve the sampling strategy, we're going to use a PR campaign as a start to have licensed attorneys in California to agree to participate in any one of the 3 surveys. And then once we have the registration results from this initial campaign, we're going to divide it up randomly into 3 groups. And whenever we have the survey ready, we'll send out the survey notification. So that's our current plan. And it has to be coordinated very tightly with the timing for the 3 surveys occurring about the same time. The current projected timeline is to send out all of those surveys during the summer.
So I've spent a lot of time on this, and at times a lot of us have gone. So I asked the question, what do I think might come out of this? And the discussions that have existed in these groups have been very, very valuable. They really have been worth the time. And it seems to me there are 3 core issues that I'm hoping that this study will really help us figure out. And a lot of the time we spent talking about skills versus knowledge. Okay. What are you training lawyers? Are we training lawyers in specific areas of knowledge? Are we training lawyers to have certain skills? And what's the relationship of those 2? And to the extent that a lot of us think it's a lot about these skills of legal analysis and research and applying law to facts, how do you test that? Okay, so that's issue number 1. Issue number 2, that being said, is there some core of legal knowledge, okay, which we think that lawyers generally ought to have as a foundation? Whether you're a business lawyer like me, or you're an immigration lawyer, or you're a family lawyer, or whatever you might be doing, given the broad range of practices, is there some common core of knowledge that every lawyer ought to have? We ought to test as a matter of minimum competence. I think many of us believe it's certainly not 14 subjects, but it's some group of subjects, and we're hoping the study might give us some insights into what a core of knowledge might be. And third, maybe some insights, these might lead some insights in terms of the form or forms of testing. Okay? What is the relevance of an exam which largely relies on multiple choice? Okay? So you have multiple choice is now half the exam in California. Number 2, types of, to the extent we test on essay questions, what type of essay questions? There's been a real divergence between California and the uniform bar exam. Uniform bar exams are half-an-hour essay questions that are very, very specific at the elements of a particular issue, like a tort case, whereas in California, these crossover essays. So essays, and then you have the whole issue of performance tests and the types of performance tests. And are there other forms of testing, more iterative and interactive? So perhaps that's a third area that this might lend some insights into. These, I think, Ron, last we're going to ask people about some, what was the final number we came up with? Subdomains of issues that we asked. There's going to be a broad range of information, and those, the way in which this is structured, the way in which Ron talked about it, seems to me it may give us some insights into the variety and complexity of the things that lawyers are doing out there that'll give us insights to each of these issues. So that's really what I have to say.
All right. Are there any questions related to the CAPA project? Okay, yes, I do.
I have a bit of a concern about the way the survey was described. Since the bar exam tests minimum competence when someone's coming out of law school, essentially, I'm a little worried about a survey sampling that would include 40-year practicing lawyers and not capturing what's needed for minimum competence. Is that being addressed?
Yes, okay, so just to repeat the question is about a concern about the surveying, because it sounds like we're surveying the universe of attorneys when the study should be focused on those entry-level attorneys. And the idea is to oversample for the attorneys, but let's let Ron answer that question. There is a strategy that will address that in the sampling strategy.
The survey population would include all licensed attorneys from entry level to all the way to over 40 or however long of experience they have. The analysis strategy is different than the traditional survey, which NCB's survey focused on entry-level attorneys and asked them, in their view, what's the relevant importance and frequency of those skills and knowledges. Here we'll be relying on the different patterns of the responses from attorneys with different length of experience to draw some conclusions about the minimum competence related to entry-level attorneys. So part of the demographic portion of the study survey will ask what's the length of your practice, whether it's from 0 to 6 months all the way through over 10 years. So that by categorizing the years of experience, we are trying to deduce some differences in the patterns of the response. So that will inform us to draw some conclusions about the minimum competence.
Jay, maybe this is a way, so the way that the survey is designed, so there are these tasks that are identified. So let's take the performance skills. So I have an example. So basically, performance domain, establishing and maintaining client relationships. Okay, so that's skill number one. So there are various sub-skills or tasks. So one of them would be define the scope of attorney-client relationship. Okay, so that would be the task. So it's a question there. And then the question is, when were you first expected to perform the task? So I believe that's a question that could be asked both of a relatively new lawyer as well as someone who is a more mature lawyer about when he or she first did that, whether it was in the first months of practice, the first year of practice, or after that. And that's really the idea, okay, in terms of when did you perform these tasks. So I think you get the perspective of both would be useful to the study. Does that answer your question?
Hopefully.
I also want to add, in addition to looking at the statistical patterns from the survey results, we'll also follow up with a series of focus groups with experienced attorneys and then entry-level attorneys to look at the results so that we can have all of those results vetted in a focus group discussion. So a couple of procedures to make sure that the conclusions we draw from the survey is solid in answering that question.
So Greg, you have a question?
Yes. For whoever, how deeply are you examining the content domains in terms of the questions on the survey, to ask people, you're not just saying, do you do anything in criminal procedure? You're obviously asking about some subparts of criminal procedure. And Steve, you just mentioned some of the subtasks within the performance domains. Can you spend just a second on the subparts of the content domains for us?
Then Farrell mentioned a number of items in the performance and knowledge domain. Altogether, it's more than 200. So under criminal procedure and law, we have subtopic domains. And the survey respondents will not be responding to these 18 or 19 major knowledge domains, but rather under each we'll give an options to select the relevant ones directly related in the experience sampling directly related to what they were doing. And then the traditional survey will go down the long list of more than 200 items in the skill, performance area, and knowledge domains. And how deep we go into also involves the kind of a rating. In the experience sampling, we also ask them about the complexity of the knowledge that they need to have in order to be proficient in performing that task.
So Greg, just let me give you an example, and these are still being worked on. So let's take a content domain 8, environmental and land use. Okay, so under that there are a series of subdomains or topics in terms of areas that someone who's doing environmental land use might be involved in. So they include due diligence for acquisition, environmental impact statements, eminent domain, remediation, regulatory compliance, etc. Okay, so on each domain there are a series of things that have identified as a typical type of issues that a lawyer practicing in that area would practice and expect to have knowledge and experience, right?
So actually that's great because it includes not only the substantive law, but actually some of the process tasks, which might otherwise only be under the performance domains, but they actually come here under the knowledge.
Yes.
You have to know what has to go into environmental impact analysis and how to conduct them. I think that's terrific.
Hi. To what extent has your study taken into consideration the fact that people's elementary, secondary, and undergraduate educations are not sufficiently preparing them for law school at this time?
So this study is looking at current bar practice, so that some of the studies I described earlier, for example, the last one that we issued in December 2018, that was the first study to marry student credentials with bar performance. And maybe it doesn't go back as far as high school and you were talking about undergraduate work. In that study, for example, we looked at the main indicators of performance on the bar exam, and that would include, for example, your law school GPA plus other, what was the other credential? An undergraduate GPA.
But so undergraduate GPAs don't mean very much. I mean, in the sense that it depends on where you went to school, what their grading processes are like. We find that people, even with high GPAs and high LSATs, don't have the kind of skills that you're going to expect of them. They don't have writing skills, they don't have reading skills, they don't have thinking skills. And I don't know how the bar can impact that. So until that undergraduate, high school, elementary school education changes, I don't think you're going to see much change in the results on the bar. I think this is a great study, but no matter what you come up with in terms of changing the bar exam, until that underlying stuff changes, you're not going to see very much change in the results.
I think you're absolutely right, and I want to refer you to the performance study that was completed back in December. And if you haven't read it, I would suggest that you read it. Because I think it points to what those, I think, 12 law schools, ABA law schools participated in it. And it basically showed, one of the things that it got rid of the myth that the problem of what's going on is that we're admitting students who are unqualified and they're not performing, okay? Because basically what that study showed is that's a minor factor. At most 50% and probably somewhere between 20-25% of the decline. Okay, the other thing that study showed that gave me good feeling is what we are doing in these schools to make up for the problem that you're talking about, which is the students who are coming to law school now, even students with good credentials from good schools, lack the skills of research and writing and analysis that you expect from college graduates. That is a fact, okay? And we're not talking about schools with students with third grade degrees and third grade. So we're talking about students from the University of California who've never done formal writing, okay? And so that's what we have to do in law school. We have to train them and give them those skills, okay? My view is one of the problems is then we have this very, very burdensome and high threshold of a bar exam, okay, in this broad range of subjects. We can't do it all in that 3 years. Do the remedy, prepare them for a bar exam, which is a very, very high cut score, give them the specialized skills and experience they need to get jobs. Okay? That is the challenge that we face. We need to solve this problem collectively by looking at every aspect of it, of the future of our profession, and the future of our state is going to be in serious jeopardy.
I couldn't agree more. At this point, it's very difficult to remediate all those skills as well as prepare people to practice law.
Completely agree.
Yeah. 2 questions. What are the variables you're looking at in terms of your sample size? Is it, you talked about time and practice, but geography, practice areas, size of the entity. And the second thing is, how open is the bar to something a little bit more different than the typical bar exam? Are we using the bar exam we're using now as the basis, or is there openness to other ways of admitting students to the bar, like the Webster Fellows in New Hampshire as an example, where it's a long process through the 3 years of law school as opposed to just one exam?
So, do you want to answer questions about the variables and
You just mentioned most of the variables we're going to include in the demographic portion of the survey. And the follow-up question is more policy about exams.
So, yes, so what this data yields will help us address everything from exam format to the content to the topic area. So, to a certain extent, we're going to use the data to help make that determination. So almost everything's on the table. I mean, we went to the NCPE conference and they were talking about their CAPA study. So they're doing the attorney performance study as well on a national basis. And they're kind of in the same boat. We are we'll both have the same task at hand, and that is ensuring that we have a bar exam that reflects the requirements for entry-level attorneys. So if that means that it's going to impact the exam format or the topic areas, then we need to act on that.
Sorry to keep asking questions. This is probably for Steve again. As the performance domain, managing the practice, the biggest competitor for our graduates today is not their fellow lawyer. It's the corporate practice of law, the big stuff. I'm not suggesting you're going to fix that here, but the question is whether we're looking ahead to evaluating whether these candidates have the ability to perform in that sort of environment, whatever that means. I know this is an area that you're concerned about. I'm very concerned about it too. Is there any talk about that piece of it in connection with what we're evaluating?
So are you referring to practice areas, like whether somebody's a solo practitioner versus working in a corporation, or?
The people who are going to survive running a practice in the future are going to be able to manage technology and resources and people a lot differently than the artisan model that we have employed for the last 500 years. And the question really is whether that is an element of minimum competence, or whether that has to be evaluated here or not.
Yes, I mean that's what we, one of the a very, very interesting moment came in one of these working group meetings when, as you know, we've come to these sessions over and over again, and we've heard about the whole purpose of the bar exam is to prepare these people go to the Central Valley and put up a thing, and they practice law, straight out of law school, and they do everything, okay? And we pressed a little bit about the number of people who go out there and start as sole practitioners. We're probably talking about 2 to 3% of the lawyers. The notion that we ought to have a bar exam that's aimed at that 2 to 3% is ludicrous, okay? And I think we've come to that conclusion. We need to address the wide variety of things that lawyers do and different places where they practice. And we need to understand the complexity and the variability of that. What that means in terms of an exam and the kind of skills you test is a question. But I think that's what we're trying to get. We're trying to get insights into the fact that that is the profession in California now. It's not, one of the things that we continue to have this myth, and you'll see some of it reflected in the knowledge domains, is that the vast majority of people who practice law in California are litigators. That is not the case. There are more people doing business, and widely speaking, than litigation. But our mindset is still very much litigation. We have one subject for business lawyers, okay, and we have multiple subjects that relate to litigators. And we continue, so that's one view. But the other thing, we continue to have this view that we're training people to go out there and hang out a shingle in the Central Valley and practice everything and they don't have large law libraries, and these things that we have in our pockets don't exist. So I think this gives us insights into the variety and the diversity of the legal profession in California, and how if there's going to be one exam, it ought to be an exam that somehow, in a comprehensive way, based on a core which is more common than not for a significant number of those people.
So we are asking questions about that.
We're having those discussions.
Okay.
But
That needs to be in the survey.
I think we should be more specific, because there are going to be specific questions about the use of technology.
Yes.
That came up at the last meeting.
Yes.
So the issue has been addressed head on, and there will be questions in the survey getting at precisely that particular skill set.
Right.
And you'll see on the skills questions that they really do delve into law as it is currently practiced, and that's been the great value of these discussions.
Another question?
Sorry, this may be a downstream issue, but with respect to a bar exam and cognitive load issues where you've got an exam that keeps growing larger and larger and larger in terms of its subject material, how will this working group deal with the fact that the MBE has its list of subjects that it's going to test, and even if California decides this corner of property law is very interesting, and we should be testing it, adding on to the body of knowledge that an applicant has to know to pass a bar exam, will there be a discussion about that? How will we make sure that the amount of knowledge is kept from growing without need to grow?
I believe that's part of the data synthesis. I mean, we talked about the focus groups that are going to happen after this, once all of the data have been collected. I think that's part of that discussion. And then the policy implication of that too is, it's happened even with the new professional responsibility portion of the question. There has been some time before that got tested on the bar exam. And so, I think two ways. One is that will work itself out in part of the data synthesis with this working group. And the second part is in terms of policy, again, everything's on the table in terms of the discussion on, we've been assuming it'd be a reduction in topic areas or the an increase in topic areas as well as bar exam format.
I might just want to add about the way we use the data to answer that question. The traditional survey based on a 5-point scale, you might get results for two different subject areas, one rating of 3.5, the other was 2.4. You make a judgment about where's the threshold to determine something that's important. But the experience sampling survey will give us more clarity about the relative frequency of the knowledge that they use. Instead of a 3.5 and 2.4, you would see data showing that 30%, for example, of the entry level is using one particular area versus 10%. So give us more precise information about the relative frequency and importance of all of that, and we can hopefully have the two sources of data converge to make a more reasoned judgment based on empirical data.
Any other questions? Okay, well, thank you. Okay, can we mute this mic? Is this one loud enough now?
No.
No. No? Okay.
Okay, thank you. Okay, how about no? Okay, so changing topics, we'll be moving to trends in moral character determinations and with a special focus on the role of rehabilitation in moral character determination. And we'll be having 3 guests. We'll be having Tara Clark, our Director of Program Manager of Moral Character Determinations, Mark Torres-Gill, our Assistant Director of the Office of Admissions, and Professor Debbie Mukamal, the Director of the Stanford Center on Criminal Justice.
Good morning. We just have a few moral character updates for you today. So the first is in relation to the fingerprinting with the new AIMS system, the Admission Information Management System. So we do ask now that the students wait until after they've submitted their moral character application to actually go ahead and have the live scan done and submit that. Part of the reason being is after they submit their application, they'll receive an email with this form, and that form will now include the associated case number for that particular applicant. And then once the applicant has completed the live scan, we do ask that they post that to the student's case feed, and we'll show you what that looks like in a moment in the event that you get those questions. And then going forward, we do ask that the schools do not host a fingerprinting day. The reason being is that the forms must be received within 90 days of service. Otherwise, they're considered stale dated, and we have to ask the students to be re-fingerprinted, and the forms are now linked to the particular case. So this is just an example. When the student signs in, this is the portal that they see. So this black outlined box, this is a sample dummy account that I have, so it's not going to look exactly like the students, but you'll see it tells them which type of application they have, and then they can see the status of it. So that way, if you have an applicant who has previously had a moral character determination and now has an extension application, we would just ask them to click on the case number, and that way that'll bring them directly to that case. And they can confirm the case number, the type of application, and the status, so that way they know they're posting the information to the correct application. When they click in the post box, that's when the little attach icon, the paper clip icon down in the bottom left corner will appear, and that's how they can upload any attachments. And so for the law schools, for the law school declarations, those were previously mailed out to you, the questionnaires, and we'd ask you to bubble them in. Now they are being sent electronically. You'll get an email that looks like this, and it does have a link for you to click on. Once you click on that, it'll take you directly to the questionnaire. And so the questionnaires cannot be printed after submission at this time, so we do ask if you do need a copy for your records, that you do print a copy beforehand. And then something since the inception of AIMS, we have actually added the option of do not wish to respond to the chemical dependency questions. You should see that on any of the new questions. I know that was some feedback we got from the law schools. And so with moral character, we do have the moral character working group. It's comprised of 7 members. So we do have 3 committee members, 3 law school deans, and Debbie Mukamal, who's up here with us today. So the working group was created to examine the existing methodology and develop clear and appropriate guidelines for determining whether an applicant possesses the requisite moral character for admission to practice law in California. So the candidates for the working group were solicited via email, and the participants were chosen by their respective groups, so either the Committee of Bar Examiners, CS Bars, or Law School Council. And we're in the process of scheduling that first meeting. We anticipate it'll take place roughly in the beginning of June. Are there any questions on those? Okay, I'll hand it over to Mark.
Good morning, everyone, and thank you for attending. You may have heard me hacking and coughing back there. I want to apologize for that. That's just a cry for help and attention, but that's just how I am. I actually have the great pleasure of introducing our next speaker. She is Debbie Mukamal. She is the executive director of the Stanford Criminal Justice Center. The center is a research and policy institute on issues related to criminal justice reform. She is the past founding director of the National Hire Network. She's a past staff attorney at the Legal Action Center. And from 2005 to 2010, she was the founding director of the Prisoner Reentry Institute at John Jay College of Criminal Justice. She has received her Bachelor of Arts from UC Berkeley, Go Bears. She got her JD from the New York University School of Law. Today, she will discuss highlights of the center's research concerning moral character and law school and state bar admissions as moral character relates to individuals with criminal records. So again, I look forward to hearing what she has to say, and I present to you now Debbie Mukavel.
Thank you. Sorry, we're just gonna.
Do you want to change this?
Change my system, just. He did it as a shortcut. Yeah, that one. Thank you. Okay. Good morning. Thank you so much for having me, and I want to thank Leah and Donna and Amy and Mark and Natalie. We've met with all of them several times about the work that we've been doing, and they've been incredibly gracious with their time and with sharing their expertise. So I want to tell you a little bit about the derivation of this project and the research that we've been doing, because I think it's both interesting pedagogically, but it's also, it wasn't where we started. It wasn't that we were like going after to try to figure out what the bar was doing in terms of admission for people with criminal records. It really came because of other work that we were doing. For the last 5 years, we've co-led an initiative working with our public higher education system in California to expand college opportunities for incarcerated and formerly incarcerated people. And as part of that work, which has been quite successful, and I will talk about that in a minute, some of our law students came to me and said, this is all great. You're doing all this work to get people into college and get them college degrees, but what are we doing to get them into law school? And I didn't have an answer for them. And what that question did was to create a class that we had at the law school last year, what we call at Stanford a policy lab. It's almost like a mini policy clinic where we take about 6 to 10 students and dive deep into a policy issue and try to come up with recommendations. Gives in terms of developing competencies, helps our students develop some policy research competencies, which, as we all know, many lawyers need, not all, but many. And the research from that is what forms the basis of the report that we'll be releasing next month on the topic. So I think it's just great that our students were really the ones that instigated us to look at this, and then it grew into a much more interesting issue. Really, we thought at first that when we looked at this topic, it was going to be a state bar issue, and what we realized is that it's actually a pipeline issue, it's a law school admissions issue, it's a law school support issue, it's all of those things, and that we equally share the responsibility if we want to try to increase access for this particular population. So what I'm going to do this morning is just, again, talk you through a little bit of the motivation behind the research that we've done, tell you a little bit about our methodology, give you a few of our key findings, which I'm going to focus more on the law school side than the state bar side. And then I wanted to open it up. I have some discussion questions that I hope will just enable us to have a conversation about what some of these interesting issues are. Before I start, I just want to say that we are not suggesting that law schools or the state bar admit anybody who's not qualified. We are just suggesting that there might be some decision-making points along the way where we're overemphasizing someone's criminal record, or maybe not having enough nuance into whether or not looking at the research that exists about the relevance of a criminal record in determining whether or not someone's qualified to practice law. Okay, great. So this is probably not a surprise to everybody, but we live in a period of mass incarceration in our country. Where more individuals than ever before have a criminal record.
In the last 50 years, we've seen a quintuple increase in the number of people who go to jail and prison in this country. We have
left the conference.
I guess they didn't like the
I'm
not going to take it. We have over 70 million Americans which is about 1/5 of the U.S. population, who have a criminal record, and about 9% of adults in the United States have a felony conviction. So we're talking about a lot of people who have now been caught up in the criminal justice system. We also know that the criminal justice system hasn't affected racial groups proportionately. There are certain groups that have been more affected. This is some data that's specific to California. The orange bars are the California prison population, and the blue bars are our state population. So you'll see that, among certain groups, whites, blacks, Asians, there's not proportional representation in prison. Interestingly, in California, unlike other states, actually our Hispanic population there is proportional representation. It's not like that in most other states. But what I want to suggest from this slide is that to the extent that we and any decision makers rely on criminal records, that can have an impact on equity and diversity goals that we're trying to achieve. So we need to keep that in mind, when we're, how we think of a criminal record, what its relevance is, and how that's balanced with other diversity goals that we might be trying to achieve. I spoke a little bit about what's been happening in California. California, more than any other state in the United States, has expanded college opportunities for incarcerated and formerly incarcerated people. The map on the left shows you where we were in 2014, and just 3 years later, we have many, many, many more community colleges, CSUs, and UCs that are either teaching inside prisons and jails in our state, or have support programs on their campuses for formerly incarcerated people. So we now have about 5,000 prisoners who are college students taking face-to-face classes, mostly from community colleges, in our 35 state prisons. We have about 15 jails that are offering face-to-face classes, college classes, and we have about, as I said, 40 community colleges, CSUs, and UCs that have programs that are specifically targeting and supporting to graduation individuals with criminal records. What that means is that there's more and more college graduates who have a criminal record. And as people get college educated, their professional aspirations rise. They're no longer interested in working at Walmart or McDonald's. They actually want to seek a professional career. And guess what? Law is something that they're interested in. Many of them were jailhouse lawyers. Many of them, because of their own cases and going through the criminal justice system, have learned quite a bit about the law. And as I'll talk in a minute, many of them have what's called the wounded healer phenomenon, which is that as they have attained rehabilitation and moved to transform their lives, they're looking back and wanting to do that for others behind them. And law is one of the ways that they see as being able to help those behind them. So, when my students came to me and said, what are we doing around increasing access for people with criminal records to join the bar, I was like, well, let's take a look at that. What can we do? So this is what we've done in the last year and a half. We did a survey of 88 individuals with criminal records to talk to them about what their interest is in being a lawyer, what their experience was in applying to law school, going through the state bar process. We analyzed the moral character disclosure statements of all 20 ABA accredited law schools in California. We interviewed 10 admissions officers at 10 of those law schools. We interviewed 7 student services officers at those law schools. We reviewed the moral character requirements of all 50 states and tried to look at where California fits in along a number of dimensions related to policy and practice. We interviewed current and former state bar officials, many of whom are in this room, and CBE members. We also interviewed California lawyers who were admitted to the California State Bar after they had had a criminal record. So we know that there are folks out there wanted to find out what their experience was. And then we interviewed California lawyers who advise on moral character determinations. Some who do it pro bono and some who do it for a fee, and we talked to a range of both of those kinds of attorneys. And then finally, we convened a roundtable of experts last spring, bringing together folks from the ABA, the California State Bar, both current and former members, formerly incarcerated lawyers, researchers, a few academics, and some advocates. I'm trying to remember. Mark was among the folks there. I think that was it. We had about 25 people in the room to have a day-long conversation about these issues. Really trying to see where can we get, where is there agreement, what are issues that are left to be sort of undressed. So what we found in doing all this work is that there's actually a number of ways along, a number of successive barriers that exist to qualified candidates with criminal records actually becoming a practicing attorney. This is not just issues related to barriers that exist because of state bar policies and practices. It actually goes all the way back to the pipeline that I indicated before. That there's a lot of folks who are not even going, they're not finishing college, they're certainly not applying to law school. They're then, admissions officers at our law schools are serving as front-end gatekeepers, keeping people out of law school who have criminal records. There are ways in which law students with criminal records are not being well supported in law school. So they're not finishing law school, and then they're not getting the help they need to go through the moral character determination process that is required. So, in specific, what did we find? We surveyed 88 individuals who have criminal records. I want to be clear that we tried to be, we tried to cream who we were going to survey. So we didn't want to just survey anyone who's just coming out of prison or jail. What do you think about going to law school? We wanted to actually take the cream of the crop. Who are the folks who are actually already graduated from college? Who are folks who identify themselves as criminal justice reform leaders? So we used an organization that's based in New York called Just Leadership USA that provides professional development to formerly incarcerated criminal justice leaders. They've now trained over 500 people in the country, all over the country. They're all people who identify themselves and are working in the space of criminal justice reform. We also interviewed folks who are graduates of or currently in some of the support programs at the UCs or the CSUs that are working with formerly incarcerated students. So those are folks who we sort of identified. They're going to be getting a college degree or they have a college degree. What are their professional aspirations and where does law fit in? So the question that we asked that's relevant here is, why have you not applied for law school? And we received 47 responses, and over half cited that they were not going to be able to pass the moral character component as the reason why they weren't applying to law school. I thought this quote sort of said it all. I thought because I had a felony there was no chance, so I never tried. So there's a deterrent effect. They're interested. I get calls all the time from formerly incarcerated students, but they're not, they're very afraid to apply. They don't want to make that investment of the dollars, the time to go to law school if they think they're not going to ever get through moral character. We also looked at the research that is pertinent to this topic. We wanted to look at how do formerly incarcerated workers do in the workplace? What does the research tell us about when does a conviction become stale, where a decision maker doesn't need to be relying on it anymore? What is the import of using moral character determination? And there really isn't very much data out there, as you may know, on the usefulness of moral character as a predictor of future discipline. There's one study that was done in 2002, and it didn't show any kind of whether or not someone had a criminal record before they went to law school and whether or not there was any indication of future discipline. There wasn't any correlation. More important research, though, is desistance. Desistance is the research that tells us when does someone stop committing crime. So when does someone who has a criminal record begin to look like someone who doesn't have a criminal record. And age and crime type are really important predictors. So after a certain period of time, usually 7 years, that's when a criminal record is stale. It's where the person's aged out of crime, or that they've been crime-free for a while, that their likelihood of doing something bad in the future matches mine, who doesn't have a criminal record. Sorry, now I just told you all. So that's important research for decision makers, right, who are trying to look at a criminal record and decide, how should I look at this? How relevant is this criminal record in the totality of all the other information that I'm looking at to decide whether or not someone should be admitted to law school and then someone should be admitted to the state bar. And in the report, we go through that research in a lot of detail. We also looked at some recent surveys that have been done on how employers think about people with criminal records. And as you might not be surprising, is that people who actually get employed who have a criminal record have quite a big stake at staying employed. They often have a parole officer who's on their back. They have made it and they want to continue to prove it. So you see a lot of satisfaction among employers for working with this population of people. I mentioned this earlier, there's this wounded healer phenomenon, and there's a wounded healer benefit. So that there's a high likelihood of people who successfully make it through the criminal justice system who want to give back. They want to go into careers like law and social work and human services because they want to go and help the folks who are still in prison or who are in the pipeline of going to prison. And there are benefits to that. They, as peers to those individuals, can speak with their experience to people who have been in the criminal justice system in really influential ways. We see that in the college programs, that having a peer who's a few semesters ahead of you makes a big deal, rather than just a random counselor who might be on the college campus. It's someone who's been in your footsteps, someone who maybe has walked your walk, and who gets when you talk about something related to having a criminal history that they would understand. I just wanted to point out that there's been some recent legislation in California that reflects this body of research. So we have something called the Fair Chance Act. In particular, that's, people have maybe heard of Ban the Box. That's where we are putting off having the consideration of a criminal record until a preliminary offer's been made. It really reflects this idea of that there's a value in hiring people with criminal records, and that there's a point in time in which a criminal record becomes stale. So we surveyed 10 ABA-accredited California law schools admissions officers. 4 of them were from public schools, and 6 of them were from private law schools. What we found is that the frequency of when a criminal record comes up in the applicant pool ranges from anywhere from 1% to 25%, but it centers mostly around 5 to 10%. So among the 10 law schools, most of them, about 5 to 10% of their applicants have some kind of criminal record. Okay? The most common disclosures are substance abuse, so substance-related offenses, so that's DUIs. It can be possession, it could be sales of substance abuse, but it's mostly that. What we also found, and this I think was kind of surprising to us, or maybe not, given, and you should tell me that, is that there was a lot of difference in how each school was asking the question specifically about a criminal record. So it's not just, have you ever been convicted of a crime? It's usually, have you ever been arrested? Do you have any expunged convictions? Do you have any dismissed charges? Do you have any, misdemeanors? But the range of questions was completely different among the 10 law schools that we looked at. And that there was also differences between how the law schools are asking questions and what the state bar application requests of applicants. So for instance, we found that half of the law schools we looked at require past arrests that did not lead to charges, whereas the other half did not. We found that the California bar doesn't require applicants to disclose charges of which they were acquitted, but that 75% of the law schools do. So those differences, there may be really good reasons for it, but what we found was that if you were an applicant moving through the process, it could be quite confusing looking at your rap sheet to understand what you're required to divulge on each of those 10 applications, and then what you're required to divulge to the state bar. Do we have any criminal law folks in the audience? Anyone? So you know like how complicated a rap sheet can be. Seasoned professionals can barely read a rap sheet.
Yes.
Certainly an individual who's gone through the system and gone through it quickly likely doesn't understand their own rap sheet. And then a decision maker like an admissions officer might have a hard time looking at a rap sheet.
And the consequences of sort of making a mistake on your law school application and
Can
then
be
the
huge.
bar could be huge as well, even if it was a mistake.
Yes, so there's a candor trap that we talk about. Then we spoke to, we wanted to understand a little bit more about why admissions officers were asking certain questions on the law school applications. 7 of the 10 said that their school considered the bar moral character requirement when crafting their disclosure requirements. That's interesting given how much disparity we saw between what their actual questions are and what the state bar requires. 8 and 10 considered whether an applicant would pass the state's moral character component when making admissions decisions. And one admissions officer in particular pointed to ABA Standard 501B, which is that the standard that speaks to a law school not admitting anyone who they don't think will become, is it a practicing attorney? I think it's not whether or not they'll pass the bar, but it's whether or not they'll go through the state bar process. Yeah. But that fuels the sort of motivation for asking the questions, which makes sense. They also, when we talked to them in interviews, cited safety, liability concerns, and a desire to assess applicants' judgment was the purpose of, again, probing people on the application for those, for that information. Half of the officers said that their schools have no policy of reviewing the applications with conduct disclosures, and only one has like a dedicated specific reviewer. And this speaks a little bit to the kind of training that I think we may want to think about that our admissions staff needs when they're looking at these kinds of records. Again, very complicated. You know, what's the difference between assault and battery? What is, you know, how long ago should a record be considered relevant in making those determinations? What kind of information should you be asking in it, you know, as additional supplemental information if an applicant indicates that he or she has a criminal record? We also were interested in looking not only in how and if applicants can get into law school, but then what happens once an applicant with a criminal record is admitted and becomes a student at a law school. And here we again saw a lot of variation, both among the law schools, but in how the admissions staff and the student services staff share and communicate with one another about a student having a criminal record. So in some, they share that information freely and kind of let the student services side of the house know, we have some folks with criminal records, these are ways that they might need to be supported. We have others who keep that information quite confidential, and they're very sort of discrete, siloed places. Most student services will talk about the moral character requirements at some point during the first year. One law school talked about having an amnesty period where they allow actually applicants to come during the first week of law school and come and correct what they might have put on their application about their criminal records. There's also variance in how they counsel and support law school students with the moral character issues. Again, some of them are very proactive. they know that that person put it on their application, they then seek those students out, they support them. Others really leave it to the students to self-identify and to come to them and seek the kind of help that they may need. Some of them encourage students to apply for moral character early on in the process, get that process started. Some of them do the kind of counseling in terms of, look, you've got a DUI on your record, you should really be going through some substance abuse counseling while you're in law school, and use that time to build up your rehabilitation portfolio. I want to also say that when we talked to the student services officers and the admissions officers, they did identify that it would be more helpful to have some transparency from the bar on what exact admission standards are for and the likelihood of their students getting admitted to the bar who have criminal records. So it's an art and not a science. We've talked about that, Mark. But that, you know, they're trying to do this kind of calculus of whether or not someone's going to be admitted to the bar and trying to counsel their students on that, and sometimes feel like they don't have enough information from the state bar about what the likelihood is. And I know that there's some information you can share, and that there's a lot that's on the website that gives direction in terms of how those determinations are made. But I think that I just wanted to identify that it is something that they are yearning for. There's also other issues that arise for students who have criminal records that fall into sort of pedagogy and career services. You know, how does Mark and I at the roundtable heard from a woman who's a successful lawyer now in Washington State, and you know, she talked about the alienation she felt being in a criminal law classroom where the professor was talking about, you know, felons and defendants, and here she was as someone who had been through that process but didn't feel comfortable going to him to say, you know, you're using language that feels somewhat derogatory, and I'm, you know, someone who's been through that, right? So in a similar way to like sort of like what kind of implicit bias training might we be considering, particularly for certain faculty members. And then for career services, I think it comes up as well. I had one law graduate who told me, you know, I got a private sector job my second summer, and they gave me an offer at the end of the summer, and I really didn't know what to do. I didn't know if I should reveal that I had a criminal record that was likely going to make it hard for me to get barred, or that would at least delay whether or not I would get barred. And there was no one in career services at my school who could counsel me on if and when to reveal that to the private sector employer, right? So these are just small issues that come up, but that are unique to someone having a criminal record that we should be thinking about or need to think about if we're going to try to increase access for this population. And I'm going to wrap up soon. What did we look at with the California State Bar? Mostly here, just going to focus on the declaration that is sent to the law schools about students and how that compares to what the State Bar asks applicants of. And there is information that's different. So for instance, we asked the law schools, but not the law students, to provide information related to students' arrest, even if the arrest did not lead to a conviction. And we asked the law students, but not the law schools, to provide information related to the students' expunged records. So it's just a question of whether or not there should be more symmetry there between, if you're going to ask the law student, why are we asking the law school something different? Maybe some transparency would be good. There was also some legally imprecise questions. I went around to our criminal law faculty and I asked, what does this mean? The question is asked on the declaration. This is the declaration that's sent to the law school. Has the student been arrested or otherwise charged formally or informally with a violation of the law? We couldn't figure out what an informal violation of the law was. So maybe having more precise language would be helpful for the law school to be able to answer the question appropriately. So we put a lot of recommendations into the report. I don't want to like go into them here. But the recommendations really speak to trying to increase access. The earlier slide I showed is about how all the ways that there's these decision-making points that are reducing access, there's these sort of structural and successive barriers, that there's ways that we could think if we wanted to increase access to this population to expand access. So, creating more pipeline programs, reaching out to these college programs that are working with formerly incarcerated students and seeing them through to graduation, making sure that they know that access to law school and access to the state bar is something that is possible for students, and being able to communicate that and really sort of address the deterrent effect that we saw in the survey that we did of formerly incarcerated students. Working with admissions officers, really trying to maybe provide some professional development to admissions officers on how they should look at the criminal record, what it means, when the information is stale and when it's not, how to assess. It's complicated. These are difficult decisions to make. Folks who've been working in this space for a long time have challenges making them. Asking an admissions officer who's dealing with so much information and so needing so many different competencies, really sort of what kind of professional development can we provide to those decision makers? Should we be standardizing the questions among the law schools so that we're asking all applicants the same set of questions and matching those questions to what the state bar is asking, so that it's not this complicated maze of information that depending on, and it's not a gotcha test, right? Because then when they don't answer the question legally precisely, then it's used against them as an indication of their dishonesty. What should we be doing to support students while they're in law school? What kind of assistance do do law students who are graduating need in getting through the moral character determination process? Some have lawyers that assist in that. Lawyers charge upwards of $20,000 to $25,000 for that assistance. That is very difficult for someone with a criminal record who likely has lost many years of income generation because of incarceration. Is there a pro bono practice that we should be trying to develop to assist in putting together those packages, developing the personal statement that many applicants provide as part of the moral character determination process for the state bar? And then what kind of professional development might be appropriate for CBE examiners who are making these determinations and needing, again, to parse through this information and try to figure out what's relevant, what's not. So I was hoping if we had some time to be able to initiate a discussion with all of you. Some of the questions that we still have are, should there be more alignment among all the law school admissions disclosure requirements? Should there be alignment with the state bar questions? What kind of professional development should be made available? Should there be a washout period after which a criminal record is considered stale or completely irrelevant? Should we say that after 7 years, we're not even going to consider it, or we're only going to consider it in extenuating circumstances? Should the California State Bar make aggregate data available on the number of applications and the types of decisions that are made involving applicants with criminal records? I think this could go a long way to providing some transparency about what kinds of decisions are being made. There's confidentiality concerns, of course, but there may be ways to get around those by making the data available in an aggregate way. And then what kind of additional research should we be thinking about as we think about opening up access? Those are the kinds of things that we're thinking about. We have this big report that's coming out. I thought it was going to be about 20 pages, but as you can see, I have a lot to say. So it's closer to 100 pages, and it will be finished the end of this month, and we hope to have it out in June. But we hope that it begins to have create some conversation about the range of decision makers and the range of stakeholders who are responsible for this issue. There's a lot of talk around the country about this issue, and when you talk to most advocates, they mostly talk about it as a state bar issue. And what we're really trying to extend is that these are decisions that are being made along a continuum. And if we do want to increase access for this population, then we need to be making sure that decision makers along that entire continuum get the kind of information they need to make those decisions. So I would love to hear from folks if, I think we have about 5 or 10 minutes.
I'll go.
Yeah.
I mean, one of the problems we've run into is there were no written standards for moral character in California. And in fact, it's my understanding most of the country, if not all of the country, doesn't have those as well. So that's the whole point of this working group that you're on. And I think once we have those written standards, the law schools are going to find a huge value to that. We'll be able to adjust accordingly. But until we actually get there, everyone's kind of operating in the dark. So I think what you're doing as a working group is critical to what the law schools will be able to do going forward. I think they're going to find the work extremely helpful, as all the applicants who are trying to figure out what qualifies, you know, as being a barrier to entry with respect to moral character or not. So yeah, I'm glad we're doing this.
You know, it was interesting because one of the ideas we brought up to the roundtable, this like sort of diverse group of experts, is, you know, should there be, you know, should we say that after 5 years or after a certain period of time that there's no relevance? And, you know, there was folks on both sides of that issue. Like, you know, there's a need for this sort of very concrete, like, yes or no, I think about this criminal record or I don't, or this criminal record makes someone ineligible and this one doesn't. And on the other side of that is that, you know, for almost any individual, you could probably argue, you know, for or against why their particular criminal record should or shouldn't be relevant. And that's where I say it's a little bit of an art and not a science, even though it being a science would be more helpful to the range of decision makers that need to look at this information and deal with it.
Yeah, and I also want to add and underscore what you're saying, Joanna, which is that I think these particular issues will in fact be discussed within the context of the moral character working group. They're important issues and they're important concerns, and you know, and I'm thankful, and we're thankful to the Criminal Justice Center and Debbie for bringing these sort of updated views of the world and applicants with criminal records, you know, to us, because one of the things that we're trying to do we'll be trying to do within the context of the working group is to update a lot of the things that we do consider within the context of how we make these decisions. And you're right, the standards and guidelines that we currently have, you know, could be more clearly articulated and updated, both for the benefit of the applicants themselves, so it's more transparent. They can more readily see what's going to be considered when they apply to the state bar and they go through the moral character evaluation, but also for staff. I mean, it's really important that staff has some clearly articulable standards that can guide those decisions. And like Debbie says, you know, it is more of an art, you know, having sort of clear-cut sort of black lines. Yes, you're in. Yes, you're out. You know, I'm not an advocate of that. I think that there has to be some flexibility. And in fact, you know, that's what we do now, and I think that is the best process. But if you're going to have flexibility, then you need to have some guidelines that are clearly stated.
Yeah.
I think this is really valuable. You know, one comment is that, you know, and I'm sure this is even more the case at Stanford, but we're certifying students from bars across the country.
Yes.
So California is just one of
I know.
many states that we have to think about in terms of what we ask when they apply. The other thing is that, you know, and we've had this situation, this is the world of Facebook and social media and things like that, where we have admitted students and then received communications about from what we'll call victims, or people somehow, you know, disclosing things in terms of records that have then caused issues. Okay, and you know, which require us to look at the disclosure the student has made, ask for elaboration, because our concern at that point is to make sure we have the record straight and the full story. And number two, also to anticipate the fact that's likely to happen when that person then goes through the moral character qualification at the state level, and be prepared for the same thing happening again.
Yes.
And in the world of social media, I think that's not going to be an infrequent experience.
No, and there's important issues around, candor there. That's not a question of was someone confused about what's on their rap sheet and what qualifies as a dismissal versus expunged versus, that's someone maybe just trying to omit information. And that's information that's important for you to know and as you say, important for their future journey through the moral character determination process at the State Bar. While I appreciate that our students, go through many different state bars, it is the case that the majority of our students probably at Stanford do go through California, and that was why we wanted to look at it as a California issue. And that most of the formerly incarcerated students are likely to stay in the jurisdiction where, we wanted to focus it on a state issue. We also are trying to convince advocates that these are state issues, that this isn't like, oh, we need to change how criminal records are, how people with criminal records are viewed in the legal profession. It's a state bar issue. You need to drill down and do the work of working with the law schools in your state, working with these pipeline college programs, working with your state bar. And so I've actually tried to steer some of the advocates away from just making this a national issue and be like, but what are you doing and what kind of success can we see in a number of jurisdictions to then convince other jurisdictions that opening this box isn't going to lead to problems. So that's part of my own sort of practical reason of wanting to do it as a state issue. Yeah.
So, I'm sorry.
No, go ahead.
So yes, absolutely, this is wonderful. Thank you for tackling this problem. Your question up there is what kind of professional development should be made available to the decision makers. One of the specific items that I would love to see come out of this, and I don't know if it's possible, is here are 5 common scenarios that law schools face every admission cycle. Here is the state bar's thinking on it. Because, for example, we'll have students who they got caught on college drunk and they did a program and there's no record of it, but we tell them disclose absolutely everything because we're too terrified of what the state bar is going to do for you, and because we have no idea what's going to happen. Yes, we have to tell you you've got to go consider a lawyer, and we know you're in the worst position to do it, but we can't tell you not to go talk to a lawyer. So you've got this situation where because the state bar hasn't given us this guidance, the only thing the law schools can responsibly do is say, disclose everything and be worried about everything. So if
Be
you
risk
can have,
averse. Yeah, be risk averse.
yeah, and that's a great thing for us to be doing. I don't think it's necessarily the best thing for the applicant. So the more little vignettes that you can actually, a la a state bar opinion letter on moral character, something like that, it would be really, really helpful to us to point to something. I think it would give us a little more confidence in terms of what we're asking in our application.
Super helpful, thank you. Donna?
Yeah, so just actually 2 points now. I was only going to have one, but in follow up to that, if we could get the law schools maybe through CS bars and the Law School Council, so the ABA law schools and the CALs and the registered, to give us those 5 scenarios, then that's certainly something that we can work on. And what we would have is, frankly, how we would respond now. And then we'll redo it after we redo the guidelines. But I really wanted to take this opportunity, since we have you all in the room, as we've mentioned a couple of times, we have this ad hoc moral character working group that we've put together that's going to be tackling these issues and coming up with these guidelines and trying to figure out what it is we should and should not be considering. So one of the primary questions will be, should there be a washout period? I've got a lot of important people in the room right now. So I'd love for you to tell us, are there other questions we should put on that list that we want to make sure as we're developing these guidelines, we're addressing something in particular? And do you have an answer that you think we should be adopting for whatever that question is, or frankly, the question that Debbie put on the table?
Donna, I'd love to hear their perspective on mental health issues and what we should be asking, if anything, in that respect.
Well, I'm not gonna let you eat in silence, I'll be picking your brains over lunch.
Great. I just want to thank you again. I really appreciate the opportunity to be able to present this information, and it's been a really productive partnership with the State Bar, and I'm looking forward to continuing to work together. Thank you.
You're going
So thank you, everyone. We will have some brief State Bar updates prior to lunch. Then we'll break for lunch and have a few announcements before we actually get our lunches together. During the State Bar update period, I will be presenting some information about our Ames computer system, but only after you hear virtually through our conference call system from Tammy Campbell, the Program Manager for Operations and Management, who's located in LA. She'll be talking to you about some of the issues related to not so much the design of the bar exam, but actually the administration of the bar exam in coming administrations, possibly this year, as well as future years. And I want to just check and see if we have Tammy on the line.
I am here.
Perfect. I'm going to stay up front with a mic in case there are any questions that you get that you need repeated, but it'll actually be Tammy who will be talking about an exploration of online proctoring as well as the sites that we use for the bar exam. So I'll turn it over to you, Tammy. Thank you.
Okay, good morning, everyone. I hope everybody is doing well today. With regards to the administration of the exam, over the past several years, administering the California bar exam has presented various challenges that have included facility availability, with the primary challenge being the proctor recruitment. The issues with recruitment have revolved around hiring a sufficient number of proctors that can be proficient at the job, as well as training the new recruits. Historically, the California State Bar has maintained a steady proctor pool to draw from for each exam administration. Over the years, that proctor pool has reduced in size due to a variety of reasons, including the fact that many proctors have been working with the State Bar for a long time and are aging out, as well as a reduction in the number of people looking for seasonal work assignments. When proctors are not available, the State Bar uses personnel from temp agencies, which increases costs, is resource intensive, and less efficient for the administration of the bar exam. Given the challenges in providing sufficient quality proctors to ensure an effective administration of the examination, multiple options are being explored to find a solution that might improve the quality of the bar exam administration. One of the options is the feasibility of reducing test centers. Based on availability of facilities, test center locations can vary from one exam administration to another. For a July California bar exam, we typically contract with at least 13 facilities across the state that includes both standard and testing accommodation test centers. Some of the regions have experienced facility availability issues as well as proctor shortages more than other areas. In Northern California, one site that has been identified is the Santa Clara Convention Center, a location consistently challenged with identifying a sufficient number of proctors. In Southern California, the standard exam sites located in the downtown Los Angeles vicinity has experienced challenges with identifying a sufficient number of proctors, as well as difficulty with contracting space based on the nature of our event. Also, in the San Diego area, the standard exam site has experienced difficulties in securing facilities based on the availability and cost of conference space in the area and the possibility of the space normally used closing. Another option that is being explored as a method that might contribute to the improvement and quality of the bar exam administration is online proctoring. Online proctoring increases the quality of proctoring as it uses both a behind-the-scenes proctor staffed by an online proctor company and artificial intelligence to detect cheating or erratic behavior. Online proctoring accommodates a ratio of 4 applicants per online proctor by combining a live proctor with artificial intelligence through the use of a gooseneck camera or the camera on the applicant's computer. To prevent access to external information on the applicant's computer, the program is designed to block access to anything other than the ExamSoft testing program and the online proctor program. Artificial intelligence monitors eye and body movement and reports back to the live human proctor. This would then allow the online proctor to communicate directly with the applicant or with the on-site Office of Admissions staff. Although there would still be proctors on site at the test center, it would require far fewer proctors than currently required. The on-site proctors will continue to provide security, facilitate the distribution and collection of exam materials, and monitor applicants during testing while troubleshooting any issues that may arise with the guidance of the on-site admissions staff. Both options have been brought forth to the Committee of Bar Examiners and were conceptually approved. In June, online proctoring will be tested during the upcoming administration of the June first-year law students examination. Staff plans to pilot online proctoring at the South San Francisco Conference Center with approximately 125 applicants and at the Doubletree Westside Culver City Testing Accommodations Test Center with approximately 20 applicants. This will provide an opportunity to see how it works and to better prepare for implementation for online proctoring during the administration of the July 2019 California Bar Examination. The test centers that have been identified for the July exam are the Ontario Convention Center with approximately 456 applicants and the Hilton Sacramento Arden West with approximately 60 to 80 testing accommodation applicants. That is all I have. Is there any discussion or questions with regards to the eliminating test centers and or online proctoring?
While you're thinking about your questions, Tammy, I'll tell you that when you talked about the difficulty in recruiting proctors, I think I heard those from schools in Santa Clara all nod their heads and smile. So are there any questions for Tammy?
Yeah, so again, as Tammy mentioned, we are exploring the possibility of elimination of some of the sites, but we really wanted your feedback and some thoughts about how this might impact your students, especially the particular sites that Tammy mentioned. These are the ones that sort of jump out at us, which is why I wanted to make sure that she specifically mentioned them to you. But no decisions have been made on this, and we're bringing it forward to you to ask for your thoughts and your opinions and get some feedback on what the impacts of that might be.
Hearing none, I'm going to take that as full support. Okay, so I am the one thing that stands between you and lunch, so I will thank Tammy for appearing remotely, and I will briefly tell you a little bit about our AIMS information management system. Here at the State Bar, we implemented a new admissions computer system this past March. And it's the way that your students registered for the bar exam if they were doing so this year. It's a Salesforce backbone platform that was designed custom for the State Bar using an exceptionally secure platform designed for government entities. We have been prioritizing working with students, and so that means it's really changed the way we do our work inside of the State Bar, but it's mostly being seen by our staff and the students, and so we wanted to make sure that all the administrators knew what was going on at the party. So right now, at this point, your students can do all of the things that they need to do online. The things that they need to do haven't changed, but we hope that we're doing it with a more convenient portal than we had before. So their first contact with the AIMS system will be when they register, as always, and I will make a plea that has probably been heard before. we encourage you to have your students register within that first 90 days when possible. For most people, this is a very administrative task, but if there is any sort of issue, it's an opportunity for the State Bar to engage with them early, and they should take advantage of that help. Though there is a fee to do so of $119, we hope that this is an investment that they will consider best expended at the start of their law school. Ames will never be the only way that we will communicate with students. We will also use our website and other means of communication, but it's an easy way for us to get information out quickly, and that's the way that we know that we'll find students. One thing that we know about students is that they don't stay still, and if they have a system where they can update their addresses as they move from year to year, update their email addresses as they change them, it really helps us to keep the materials updated. In addition, we want to be clear that while we still have paper applications available, we've actually truly moved everything online. And so students will get the fastest service if they use the online systems. And in one place, we found that your students listen so well that I'd like to take a minute and give that some special attention. For those students that are applying for testing accommodations, over the years, we've asked them to please be sure that they mail in original declarations from their providers. And so that has made students nervous to upload their documents. But I'm here to tell you that yes, discard that information from the past, step into the Ames system, and now they can take those declarations and send them via an uploading portal. You remember from Tara's presentation, a little paperclip, they'll see the same for theirs, and so they should upload those declarations from their treating professionals. And we'd like to get this word out to the schools as well, so some of you may have signed when you came in a sheet letting us know who your testing accommodations coordinator was. If you haven't, we'll have it available at lunch as well. Just so we can keep them updated and remind them. The students want to be very sure, just as with the moral character applications, that they do this in the right way. And in an abundance of caution, many have been sending in paper declarations, which have been keeping our staff very busy doing data entry when we would rather process those applications and get the materials back to the students. Okay? Are there any questions about the Ames system and what the students are seeing? Okay, well, so far I'll say adoption is good. Amy tells me that when the system opened, during the first 2 hours, we received 2,000 registrations. And we've been happy with the feedback, and we hope we've been responsive as well. With that said, I'm going to cue Tom that we can get ready to turn to lunch. And when I get the signal, so we're off camera at this time. This portion of the assembly will be doing joint presentations with our Council on Access and Fairness. We're going to be starting with a discussion on law school retention for students from diverse backgrounds. This will be a facilitated discussion with Judge Brenda Harbin-Forte. So if you had a few too many cookies, I'm pretty sure that she's going to wake you up and get you talking. We're interested to see what the schools are doing. I'm going to ask our Director for Access and Inclusion, Helen Hong, to introduce our distinguished panel.
Good afternoon, everyone. It's wonderful to be here, and thank you so much for taking time to join us. Thank you, Natalie. My name is Helen Hong. I am the new Director of Office and Inclusion here at the State Bar. And this is really an integration of offices that focus not only on funding for legal aid programs throughout the state of California through IOLTA revenue, but also integrating the BAR strategic plan to really focus on diversity and inclusion and access, with the goal of having our attorney population mirror the rich demographics of our state. With that, I am so pleased that Honorable Judge Brenda Harbin-Forte was able to join us. That's why I wanted to start right on time. When you have a judge on the panel, you want to be timely. And so she will be, I'm going to introduce her, and then also Elizabeth McGriff from UC Hastings, along with Elizabeth Hom, our Program Director of the Office of Access and Inclusion as well. And so with that, I'm going to have Judge Brenda take over from here.
Okay, good afternoon. Let's talk a little bit about the goals for today's discussion, but before I do that, I want to indicate that law school retention is really just one piece of the many areas that our profession can and needs to do better. We need to increase access and inclusion. And so what we plan to do today is to talk about how we can get more support for students from diverse backgrounds to ensure that they graduate from law school. So one of our goals is we hope to develop a common plan to reduce the number of students of color leaving law school before graduation, and they appear to be leaving at disproportionate rates. We want to have a presentation on attorney population, on California Law School's data, and also current activities. We'll talk about best practices to retain diverse students, and we will talk about efforts the State Bar can engage in to support law schools. I do want to say this. We need you. We need your input. We need your thoughts. We need your creativity. We need your ideas today. So I am hoping that we will have a robust and energetic and informative discussion this afternoon. The State Bar's mission statement. As you can see, the State Bar's charge is to increase greater access and inclusion in the legal profession, in the legal system. This change is in the mission statement, which is adopted, and also in the legislative statutory mission statement as well. And so we talk about the Bar's goal to talk as well about the Bar's goal, and the strategic plan now includes a revised goal to achieve a statewide attorney population that reflects the demographic population of the state. In fact, that rich demographic population of the state. The Bar understands that this won't happen in 5 years or so. It is going to be a long-term goal, and it's going to be broken down within various objectives. But the strategic goal, number 4, was just recently adopted in March of this year. Our diversity and inclusion objectives. There are 2 objectives that are focused on law schools. The first is supporting retention of diverse law students, and we'd like to learn about and discuss that today. The second is working with the California accredited law schools and registered schools to develop enhanced reporting requirements. And the State Bar staff is working with the CS Bars, the Committee on State Bar Accredited and Registered Schools, on that aspect of the objectives. And now we'll move on. I'm going to turn it back over to Helen to give us some graphs and slides and magic and everything.
Well, like Debbie's presentation, I don't think this is gonna be a lot of surprise for you, but we wanna make sure that this information is grounded in data so that we can move towards improvements in what we see. So when you see this graph, you can see that the attorney population does not reflect what we would hope of the population of our state. So if you can see this, that 41% of the attorneys, 67% of the attorneys are white compared to 41% of the population. But you see the biggest disparity in the Latino population, with only 6% of the attorneys, where 35% are of the state's population. Some of this data is actually recently coming out of our My State Bar profile, which we're asking all active attorneys to fill out. So we have a better understanding of who our attorneys are, and then also gathering more information about career satisfaction and career opportunities. You can see that it's actually pretty even within the male and female, and the non-binary is a new category of those that do not necessarily identify with just being male or female. And so 6% seem to be coming a little bit more from the female population than male. And when we look at what the state trends look like, we can see the disparity gaps of law school JDs that are being awarded. Meaning for every 100 white students, only 10 black students have obtained a JD. You can see nominal improvements with the Latino population, and it's been pretty stagnant with the API population. But what we're really seeing in terms of the ABA data is that when law students are entering into graduation, we're seeing a disparate impact of the attrition of students from diverse backgrounds actually graduating from law school. And this was perfectly when I saw Debbie's funnel chart in terms of who's applying and then who's actually graduating, so decreasing. We're seeing a disparate impact. Now, we have this data from the ABAs, but we do not have it for the California registered and accredited schools. However, we do have the data of who's enrolling in California registered and accredited schools, and they do appear much more diverse. And so when I presented to the CS bars just 2 weeks ago, we really wanted to have a better understanding of the opportunity schools and who they are providing the opportunities to, and to see how we can support them to graduate as well. It's great that they're entering, but how can we make sure that they're also progressing? And so, because we have limited data, we are working with the CS bars to update and to hopefully move forward on the annual report that they submit to the California State Bar to track some of this data.
Before we move on to determining best practices for law school retention of diverse students, I want to give you a little bit more about my background. First, I've been on the bench for 27 years now in the Alameda County Courts. Double there, Cal undergrad, Cal Law School. But I've been working on diversity issues. I was the first chair of the State Bar's Council on Access and Fairness when it was formed, 2006, 2007, around that time. I am now the vice chair of the State Bar's COAF. So we've been working on, and I've been working on these issues of diversity and inclusion for many, many years. And before that, I was working with California Women Lawyers, presenting programs on how you want to be a judge and doing a lot of stuff on judicial diversity issues. I started that in I think 1988 or so, and 1998 rather, and doing that. So I want to talk about that, and I guess I say that as well to let you know that it is a subject about which I can be very passionate, and I hope that I can encourage you and inspire you as well. I hope we can have some very honest conversations about these issues, very candid conversations, and we can really sit down and try to chart a path forward and figure out what we can do. But we do understand that with respect to law school retention of diverse students, that's just one facet of what we need to do to increase diversity in the legal profession. As we'll be discussing today, the State Bar is continuing to look at things like the bar exam, promoting passage through programs like the California Bar Exam Strategies and Stories program, and engaging in other diversity efforts. But this part of the pipeline, that is from entry into and exit from law school, is critical. In fact, I am going to say that we are at a crisis point when it comes to that issue. We have got to start doing something to address this critical issue, and we need to have some sustained attention paid to it as well. Today's discussion is going to be on effective programs, and what we'll do is we're going to hear from about some programs, things that have worked in the past, things that can work, and we hope to come up again with a plan. Based on this survey that Helen's team has done, and that the Office of Admissions sent out, we have gotten 2 volunteer law schools who are going to present. One will present, Hastings is going to present in San Francisco here today, and then tomorrow, Hastings is going to present in LA as well tomorrow, along with Loyola Law School. But they're going to present their programs. We know that students of color are leaving law schools at disproportionate rates, and we're going to try to figure out what, if anything, we can do about that. So we've asked for a short presentation on what these law schools do, how they measure success, and what are some of the key components they feel that have enabled them and assisted them and that have made the most difference in terms of supporting students for graduation. We'll turn it over to Elizabeth McGriff.
Good afternoon. My name is Elizabeth McGriff. I'm the director of the Legal Education Opportunity Program and Equity and Inclusion Advisor at UC Hastings College of the Law. I am also a graduate of UC Hastings, and I'm also a product of the Legal Education Opportunity Program, also known as LEOP. I'll just give you a quick snapshot into my background. I was a trial lawyer for about 10 years. I worked in big law. I worked as an in-house counsel attorney, staff attorney, legal assistance for seniors. I was a chief legislative aide to a member of the Board of Supervisors, and I was an educator before I came to law school. I've taught elementary school, middle school, high school, college, and law school. And I also had the great fortune of working at Golden Gate University School of Law. I think Dean Nwadeki is here today, doing what is now called career services, but also student services there as well. So I have a really varied background, and I've worked in East Palo Alto, East Oakland, West Oakland, and Bayview Hunters Point, which underscores the scope of my exposure and experience to working with students from underrepresented backgrounds and underserved and under-resourced backgrounds. So it's a very mixed background, and sometimes I used to wonder why it was so varied. I enjoyed all of my jobs, but it has all come together really beautifully in this role that I have now, because students have so many different interests in terms of what they want to do with their JD degrees, and also having a really and truly fundamental understanding of the irreducible needs of the LEOP type population. What happens with the LEOP program? What was founded in 1969, we are presently in our 50th year, which is very auspicious, and I just brought in, my first class that I helped to recruit and admit will take their final exams today and tomorrow, and they are the 50th class. I am pleased to report that the class that I recruited, my first class that I recruited and brought in, has had the highest academic performance of any LEOP class in the history of the program. So we are succeeding in a significant way on that front. LEOP was created to open doors of opportunity for students who have overcome significant advantage to have access to a premier legal institution, and that would be UC Hastings. It is novel in some respects. I think the least of which is that it has been such a long-running program. We have more than 3,000 alumni to date, probably the most prominent of which right now is Kamala Harris. We also have Jeff Adachi and many other very successful attorneys, whether they're partners at law firms or running their own corporations, etc. But the overarching view of LEOP is part admissions, so this is my job, admissions, academic support, which includes 1L through 3L, as well as bar support, and community building. Now, under each of those umbrellas is a veritable potpourri of all kinds of things that go on that aren't always memorialized, but at the end of the day, it really is almost like running a mini law school within a law school, because I also end up doing a ton of professional development, career development, student services, and I've developed a lot of partnerships. So I get to review the LEOP applications that come in, and we have committees, there's a full committee, and it's an amazing opportunity because what you're doing is you're reviewing these applications and you're trying to figure out who are the students who are going to be best suited to this program and who really are most deserving of a seat in this program. I'm also happy to report that for the first time in 5 years, so our goal is to have about 20% of the population be LEOP students, and we've been below that. I just started in December 2017. This year's incoming class is double what the size of the class is last year. We have 80 deposits and we typically have about 45, so the interest in the program is growing. But I'm looking for what I call the LEOP Lite. So when I review these applications, you're looking at the metrics of the students, and one of the things that I like to debunk is often people who are familiar with the program are under the belief that the metrics for LEOP students are significantly lower than those for other students in the general population. That is not always true. I have many students whose scores and metrics are much higher than the mean at our institution. So I want to be real clear about that. There are some that are lower, but there's a real mix. It's a kaleidoscope. And that is showing up in the work that the students are doing. But I'm looking for students who are going to meet the objective criteria, but who really have overcome challenges that the average person has not faced. I mean, I read applications of students who were homeless and their parents worked at 7-Eleven. And so every morning they're getting dressed and prepared for school in the 7-Eleven bathroom. They're eating their breakfast in the car, and they're going to school every day, and they're still achieving. And these are just basically students who have outrun the obstacles. They've outrun economic deserts. They've outrun educational disadvantage. They've outrun just general poverty and discrimination, and yet and still they have succeeded anyhow. And it's really remarkable. There's this sort of tingle I get when I see that student that I know is going to knock it out of the park. And so there's the objective factors, and then there's the qualitative factors. And once the students are there, what we do is, so we're not a race-based program, but what happens is, as a de facto matter, we tend to have more students of color in our program than the general population at the school. But it is still diverse. We have students who are disabled, LGBTQ students, students from different racial backgrounds, etc. But once they're there, starting with a one-week orientation, which we kick it off with a big reception for the students and their families, which is actually one of the greatest parts of the program, because what you're starting with is community. It's a very low-stress situation. I roll out the red carpet for them. The students get to meet everyone in a very comfortable atmosphere. And then Monday through Friday, we get down to work. So we do academic programming, which is part of it. But also what we're doing is we're introducing the students to the various departments at the institution. We're bringing in alumni to speak, and Jeff Adachi came last year and spoke and also presented one of his movies. I brought in a gentleman a professor from Pepperdine, who specializes in going around the country and who does a 2-hour presentation for students from under-resourced backgrounds at Harvard and all other places. It really helps to unlock the key of understanding legal analysis and how to view cases and such. And he was a huge hit with the students. And we go to the Supreme Court. So we have a big field trip to the Supreme Court, and the students meet with 2 or 3 of the justices there, and they sit in their offices and actually meet with them. We have several social opportunities, and I do a whole section called Woven, so that the students, they're all broken into 4 cohorts, get to know their peers. This year, what was remarkable is as they signed in on day 1, within 5 minutes I looked up and they were all standing around talking to each other, which is highly unusual. Usually it takes a while for students to warm up. So I really didn't even need to have a woven section, but I did. So the students, when we're done with orientation, they'll go to general orientation. By then, they think they, know the whole place and have it dialed. And then we get to business with having weekly tutorial sessions for each of the doctrinal courses. And I have an academic support specialist that I work with, and we figure out what our program is going to be for the year. So each of the cohorts will have a LEOP tutor, and they're usually a LEOP student, an upper division student, who did well in that course, and they meet on a regular basis. And the students like that because they feel, I think, empowered to ask questions that perhaps they might not ask otherwise. And we do Saturday practice exams. So every Saturday, the students are coming in, they're doing practice exams, and then they're getting feedback within a very short time about how they performed on those exams. What I have created this year is something called the Doctrinal Faculty Partnership. So for the first time ever, we're getting doctrinal faculty who come to the LEOP suite and actually hold office hours for students, and I provide lunch. And it's actually pretty revolutionary for our program. Historically, that has not happened, but it's been a runaway success, and they've been able to recruit more and more professors to do that. And we also hold academic workshops on exam writing, brief case note-taking, brief writing. And this particular class that I have this year is highly engaged. Anything you give to them, they're going to eat it up. And it's one of the things that I actually select for when I'm looking at students, is students who are really driven and really focused and tenacious and are focused on success. And it is borne out with this class. And we also have a faculty student mentorship program, which is really amazing. So we have about 8 or 10 faculty who've agreed to take on a number of students as their mentors, and every semester I have 1 to 2 social events. Most often it's been a faculty member hosting all of us at their house, which is also groundbreaking for students who come from these kinds of backgrounds, because they don't often have such close proximity to their professors, and it actually empowers them to go speak to other professors at office hours, etc., which breeds further success for them. And in addition to that, I partner very closely with Career Services. I have them come over and do special programs for 1Ls, 2Ls, and 3Ls. I do a tremendous amount of one-on-one academic and personal and professional counseling in addition to my institutional obligations. And it is the joy of my life. And I really think when it gets down to brass tacks, that is one of the key things that helps students to retain students from diverse backgrounds. It's the community, and it's seeing them. You have to see, one, you have to really like students. And I know that sounds like a foregone conclusion, but you really gotta like students, and I love students. So it's the joy of my day when they come in. They always come unannounced. I mean, they make appointments, but mostly it's unannounced. And they come by for God knows what. I had one kid who came in and used my extra desk to iron a shirt for some interview he had to go to. And we just keep it fun, and so that they know that I will be there as an advocate for them, and I will be tough with them, but I also am very soft with the students. They need a soft place to land. And within LEOP, I think students have found tremendous community, and that really is a big factor in tethering them to the institution and following through to completion. I also, for the 3Ls, have an extraordinary man who comes in each spring, and many of you may know who he is. It's Richard Sakai. Who has been at USF for many years, but also has taught essay writing for the bar for Barbie for 30 years. And he's just unreal, very special person. And he comes in for 8 weeks and works with our 3Ls in the spring semester to really give them a leg up on their preparation around essay work, so that by the time they get to their commercial bar courses, they've had a tremendous amount of feedback, because you're only talking about maybe 20 to 25 students, so he gets to work with them very closely. So that gives them an additional advantage, and it's something that we really insist that we do each year to make sure that they have that. And it also gives them a psychological advantage to feel like they've gotten feedback.
Has joined the conference.
And then he agrees to work with them through the summer also, which is really quite helpful. So, and I will say that I talk to students all the time about different challenges that they have. And there are a wide range of them. A lot of times their challenges are financial. And to the extent that I can help them close those gaps, I do that. I do a lot of connecting students with mentors and networking. The bumper crop of jobs that the 1Ls have is mind-boggling. all of them had like 3 to 5 job offers and had to figure out which ones they were gonna take, and it really top flight institutions. And so what happens is then throughout the summer, they, they'll call and text, well, this situation came up, what should I do? So then I'll write them back. I just had a girl try out for a trial team, and so she came in and we rehearsed her closing argument. She actually made the trial team, and we had a bunch of students make moot court. And so I do, I believe in mentorship, but what I really like to do with students, and this will become more formalized, is have what I call success coaches, so that students are paired up with upper division students that they feel comfortable with, that they can talk to about various things, and the upper division students will check in with them. I have one student who's a 2L right now who is so brilliant at this, and his mentees have really benefited, and they're just flourishing. And so my thing is, students don't care what you know until they know that you care. And when you start from that premise, everything else falls into place. But you have to roll up your sleeves and do the work. And so I'm constantly doing the check-in. How's this going? Or, if I find out that they got a job offer and they didn't tell me within 24 hours, they know they're in a world of trouble, because I want like real-time updates. But I think they just really enjoy the attention, and I enjoy spending the time with them, and they love their peers, and they really rely on each other, and they really help pull each other through. So it's just a tremendous community. And last year we started having a LEOP breakfast for admitted students and their families. We had 18 students come. It was lovely. This year we had 55 RSVPs, and we had over 100 people there, and it was amazing. I think we did run out of food, but the students brought their families, mothers, sisters, cousins, aunts, and we are pulling in students who've gotten into terrific law schools, who are terrific as well, but who've made them tremendous offers, full rides in some cases, and they still elect to come to UC Hastings, to come to LEOP. And so, we're still always trying to keep our foot on the gas. I'm always looking at ways to improve the programs and to enhance the students' experience. This year is going to be a nice challenge, because we're going to have double the students. And so we want to keep the level of quality. But for me, it's all about running a high-touch program. So now the challenge is going to be, how do you continue to run a high-touch program with double the amount of students in the incoming class? And there's got to be a way to do it, and we'll figure it out. But that's my sort of general overview. And we will be having a big, fantastic celebration in October to celebrate our 50th anniversary, so we're looking forward to that.
Thank you. It's amazing. And so just to follow up, while you got this invitation to the Law School Assembly, Elizabeth Hahn had reached out to all the law schools, the admissions, to see what kinds of programs do you support, what kinds of programs do you have, even if they're formal or informal, to support students from diverse backgrounds. And I want to be clear that the Board of Trustees adopted the government code for what diversity is, but we also understand that diversity in California is can be first generation, right? It can be really defined in different ways, but we are really focusing on individuals and populations that have historically been not represented in the legal system. And so we got a couple dozen responses, and some of the things that we really wanted to highlight, we're trying to figure out, well, what do schools do? How can the state bar help propagate some of these best practices so not everyone is just kind of doing the same thing, and what has been effective? And so how are people tracking the results and seeing what programs are actually addressing that retention issue, and seeing how we, the state bar, can then support that. So with that, we have some discussion questions, and I'm going to hand it back to Judge Brenda.
Okay, all right. In terms of our group discussion, we will try to talk about what types of services or enhancements appear to be the most impactful to support students from diverse backgrounds, to help them succeed in and graduate from law school. We'd also like to talk about the unique challenges that diverse students face in law school that might explain the disproportionate attrition rate, and also, again, what the state bar can do to support programs. I really want to just try to open up the floor and start trying to get your ideas and your thoughts. We've heard about an excellent program at Hastings that is getting students into law school, getting them through law school, getting them out of law school and into the profession. What did you hear just even from this presentation that you like, that something may be, that you think has had the most impact? If we can kind of start there, anyone who sort of wants to share, what struck you about the LEOP program? Yes.
Well, I was very impressed with everything, Elizabeth, that you were talking about. And I know Dick Sakai, and he's spectacular. And one of the things I was thinking is if we had something even similar, every student would want, in the school, would want to participate in that. And how do you deal with a student who would like to participate in some of those activities but are not part of the LEOP program?
Well, it's a very good question. It does come up from time to time because oftentimes the challenge is, for whatever reason, when students apply, they may really be a LEOP eligible student, but they're not aware of the program. I'm not sure why that is, because there is a box on the application that says if you're interested in applying, but I think sometimes they just don't know what it is. And so there are missed opportunities in that sense. But what we try to do, I mean, from time to time we will transfer a student in, but really what we work on right now is our academic support program overall at the school is called OASIS, which stands for Office of Academic Skills, Instruction, and Support. So we have a LEOP, but we also have a general academic support program at the institution for students in general. And if LEOP students want to participate in some of their offerings, they can do that as well. So I think from time to time, sometimes there's something that we're doing and the academic support director there may want to see how we can partner. We do some partnerships. I noticed that our students were struggling with the MPRE, and I felt that we really should do a workshop. So I worked in partnership with the bar passage director to develop a workshop for all students so that they can also have access to that. And sometimes the general academic support people can sort of figure out how they can provide similar things for the students at large. And sometimes they don't, but it is kind of what makes us special is that, you know, because I don't have 900 students, I'll have 160, which is still a lot. You know, there's ways to tailor that, but I'm always open to working collaboratively with other administrators at the institution to see if we could do something that would benefit students at large. I also feel very strongly that the performance test is very de-emphasized in bar preparation, and I felt that we should really do something about really earmarking a focus on performance test improvement. So now the general body is going to get that as well as a part of their bar passage package that the college offers, so that all students can benefit from that. So that's usually the most effective way that we found to do that so far. But from time to time, people just are sort of like, well, gosh, I wish I had known about that program. But we just try to do the best we can for all the students. But I try to collaborate.
I can follow up on that question. One of the things that we did see in some of our survey responses is that people had programs that they said supported populations, but they didn't call it anything. So they said that, oh, we offer it, but it's not necessarily a diversity program or first gen. And so kind of following up on that, is there a willingness, or is there, does it help or does it hurt to call something a specific program?
Well, I'm Brian Bertilla from Empire in Santa Rosa, and our school population is pretty small. I don't see calling the program something special for a segment of it being very beneficial to us. I mean, I would love this program that you described for all of my students. I'm still trying to search out what kind of academic support programs I can sell to the people who write the checkbook over there. But I mean, almost half of our students are of color and women or from other identifiable class that we don't even have names for yet. You know, so I couldn't see separating out a program. For me, I'm like what Dean was saying. I would love this kind of thing, but it would be for the whole school. And I received a survey earlier from in the year from the National Association of Women and Minority-Owned Law Firms, and they wanted to know some things about what I was doing. And then there was an LGBTQ survey that I got, and I felt, well, sorry, I don't have programs. Like, I don't even ask those folks those questions, and I sometimes wonder if I should be. portion?
Well, I think you're uniquely positioned because I do think when you have a smaller institution, that you tend to have to customize your program according to the size of your, of the college. When I worked in GGU, which I just loved, they're very different schools. GGU is smaller, and what's nice about that is, in some ways, I think you can be more nimble in your programming, and you can do sort of a broad thing that it can accommodate all students. I think one of the things that I think is important at our institution for all students is I have found that there are significant deficits in students' writing abilities these days, even when they come from top-tier institutions with high GPAs and high LSAT scores. So my big thing, and I'm sure people are probably tired of hearing about it, is really developing some programming around developing and reinforcing fundamental writing skills, because some of the rudiments are not there. And those are the kinds of things that I think can benefit, you know, an institution at large, because you know, I always tell students, listen, this is the stock and trade of lawyering is words. So if you don't do words well, you know, this might not be the best thing for you, or you need to work on that. But I think that you smaller schools or schools that are differently situated can find innovative ways to really accommodate their entire institution. Hastings is a very large school though. But when you're small like that, I think, you know, it gives you a lot of freedom, I think, to create things.
And as we look at the pipeline overall, the dropout, we're losing more students of color than we are losing other students. And so we look at what we sometimes used to call the leaky pipeline. We want to explore what is it that is not allowing, what is preventing students, law students of color from getting through law school and graduating law school. And that basically is what we're trying to focus on now. What can we do? What support can we provide to them to increase the percentage of students of color graduating from law school? Yes.
For us, it is most often a financial issue.
Yes.
And one of the things that we had come to us was, I think it's your Access to and Fairness Diversity group that put together a Pathway to Law, which starts in the community college, and it's a 2-2-3 program. Yeah. And we had our local community college come to us, the president of the college, and said, we love the Pathway program, and the problem is that our students get to the point where they are accepted at the next two, and they don't have the money. And why don't we, since at least the Cal accredited schools can take those students after community college with 60 undergraduate units, why won't the state bar support a 2-4 program, 2 years at community college and then 4 at one of these local schools? Because you know, a lot of the community college students, it's sort of like the prisoner program where you don't even get them in the pipeline because they're looking at another $100,000 for 2 years at undergrad and then another $180,000 to go to law school, and they won't even start. And so if you could show them a path that said, here's community college in San Jose, it's free for those first 2 years, and then you could go to a state school that's, you know, $60,000 or whatever it is, that's doable. And that's a point where that might work for them. And there's no known pathway, there's no state bar supported pathway to do that. I don't understand why.
Just digging in a little bit deeper, so is the financial, are you seeing people drop out because tuition, because they can't
get that next year worth of financing?
Well, but are they in your school and
Yes.
then dropping out?
Yes.
Okay. Okay.
Yeah, and some of that is because they've got all this undergrad debt.
Okay.
Right? And then
Okay.
they go to get their law school loans and they can get that first year and then they get denied the second year, or something happens with their job or whatever it is. Or they just don't even, you know, there's that segment that won't even apply or that can't qualify because they had to do that extra 2 years of undergrad because that was the pathway.
Thank you.
I understand what she's saying, but don't be deterred by not being included in the state bar created pathway. We have created our own pathway with 2 of our community colleges and Fresno.
Well, sure, as have we, but we have our you know, some of our students and some of the community colleges are asking, why is it that the State Bar won't include that as a sort of a sanctioned pathway so that those community college students, because when you go to the community college, they have their pathway program in a brochure, and it says, here are the colleges that are signed on to this program, and they're all ABA 4-year institutions. So they look at that and they say, that's the pathway, and that's the only pathway that the State Bar has for me. So if we could put our state schools on that brochure, that would make a difference, I think.
Okay, all right.
Especially since at your community colleges, you usually have an extremely diverse student population.
Exactly that. That's why they came to us and said, we're looking at your student diversity numbers and ours, and they match. And it's their students that are coming and saying, we would love to do this program, but we get to this point and we can go no further because we didn't get a scholarship.
And the financial barriers are incredible, and they certainly cannot be understated. And sometimes they're very practical needs that students have. Anyone want to talk about some of the issues, some of the financial issues facing students? Carmina, I'm going to put you on the spot. Yes, indeed, I'm going to put you on the spot and talk about some of the.
One of the things that I know about is that the financial support, which we all agree is necessary, even that financial support, when the schools do give it, yay, hooray, is structured in such a way that it doesn't allow for some of the diverse students' financial needs, which might be a little different from other students' needs. For example, I had a student who was hysterical because his car was broken into and his laptop, which he had bought used 2 years before in college, was stolen. And he came to me and said, I don't have money, I can't buy another laptop, not to mention get my windshield fixed or my car fixed and all that. I mean, his immediate need was all his schoolwork was on that laptop. And when he went to his financial aid, at Hastings they have a thing that's a student account, and it's pluses and minuses, and so the tuition goes right in, and then any aid that the student gets in terms of a loan or a scholarship is put into that same bucket. Unfortunately, those monies that come in are applied against the tuition, which is something that I really don't agree with. There's no way for the student to get his hands on maybe some of that scholarship money that he could have taken to buy the new computer. So that's not your problem. It's a financial aid law school problem. But a lot of the students I work with need money for rent. Yep. They're not getting the cash out of the schools. The school has got the student into this place where they say we have online, they don't even call it a bank account, they call it the student account. But the students can't get any cash out of it. If they run short that month and they need some food, or they lost their Muni Pass, or any kind of contingency or emergency, now I do know that there are some emergency funds, but that is a financial problem that a lot of the students who are not of general population, who do have special and extra financial needs, they grapple with that.
In the same vein, I think.
I'll come to your seatmate.
Oh, I'm sorry.
I said, and then I'll come to your seatmate, so you go ahead.
Okay. Just the population, students that I've worked with also tend to have so many more responsibilities than just themselves, that when they have crisis in their greater family, it really falls to them, whether it's their parents, their grandparents, their niece and nephew, their children, that also becomes, I think, a real detriment to going on in school. Because they're making really big decisions that affect their entire family and their structure, and it's a lot of pressure on them. It's pretty difficult and intense.
So one issue that we discovered at Santa Clara, which we were surprised about, was food insecurity. We ran a survey a few years ago and found out that a shockingly large percentage of our student population was food insecure, and so the law school started, and the university followed up with a daily food offering every day at lunch, and then the university has a food pantry. So that has been a program that has been really, really helpful in addressing these basic needs, that because we tell students to make sure they're spending their loans wisely, and that's a great thing to tell them. We counsel them on it, and then it doesn't matter whether or not they take that advice. if they can't eat during finals, they can't eat during finals, and that's a problem. So that has been hugely successful to making them feel taken care of, and we think actually helping. We can't run you data on that because, of course, the program is meant to be anonymous, so I can't tell you that 14% of students increase their GPA by a point whatever because of this program. And I'm okay with not being able to tell you that, but we think it works. Another program that we found that's not necessarily related to any diversity of a group that might appear on admissions is first generation. So anyone who's a first generation student, that community has really grown. They found some support in that. And then a financial concern that I would raise that I don't think is very popular to talk about is the reality that a lot of law schools, they offer more scholarship dollars to their incoming class as a way to bring in that class. And then if you don't hit your GPA by the end, you lose your scholarship. And we know we are losing diverse students because they have $25,000 of scholarship pulled out from them under the rug, and they're looking and saying, I can't finish 2 more years of this without that money. So I don't know what to do to address that, but it's a concern.
And what law school are you, by the way?
Santa Clara.
Santa Clara.
Santa Clara.
So just following up on that question, so when you do offer scholarships, is there specific programming in order to support those students who are primarily diverse?
Yes.
And they're still not?
Yes, I mean, it's just a GPA issue. I mean, a certain percentage of the class just cannot reach that GPA because it's a curve situation. And, you know, we offer the support for it, but we can't control the outcome in every situation, of course.
Suggest they transfer to a Cal school.
Can
I ask a question? Just because I was wondering how much of this attrition is kind of tied to GPA and sort of schools moving students out who they don't think ultimately are going to be able to succeed. And you raised just this other interesting issue about the curve that I haven't heard about as well. So I'm just wondering that we've heard about financial issues driving attrition, but are you all also experiencing that sort of pressure to weed out students who you don't think ultimately are going to be successful, say, on the bar exam? Is that also one reason for these high attrition rates with certain
How do you
populations?
define success on the bar exam? I think we overemphasize first-time success. And many of these students would succeed on the second or third attempt. And that would eliminate some of the pressure that some schools feel to get out the people that they think are going to contribute to their first-time pass rate.
I'll speak. I'm an ABA accredited school, and the ABA puts emphasis on the first-time bar pass rate. And I'm one of the schools that have actually suffered because of it. There's a rule that says that you can't admit students who aren't capable of being a member of the bar or completing law school. And so what that does is it forces us to bring in students that in California at a much higher level than they would if we went next door to Nevada because of the bar. I mean, the bar cut score hurts schools like mine with access and opportunity. And so we can't even admit them. And then if they don't do well, we have to let them go because we can't have the ABA coming back and saying that you can't. I mean, it puts us at risk. We were cited because of this particular rule last year. And so that we had to dramatically change it.
Following up both of these comments, so I'm with JFK, so we're a Cal Bar accredited school. And regularly, we will have people who are academically disqualified from Hastings, Golden Gate, or USF, and transfer to our school, and whether they start over their education or we were able to, depending on when they're academically disqualified, we can give them credit sometimes. And in a smaller class setting, they regularly function at a much higher level, stay in school, graduate. As Jan said, it's quite a bit less expensive to attend a Cal Bar accredited school than an ABA school. And they succeed on the bar examination. And I, over the years, have had relationships with people at ABA schools and receive calls and say, hey, this student is not, we're feeling badly, we have to academically disqualify the student, but I have permission to contact you. Would you consider having this person enroll in a smaller setting and having, so one of the things, I'm just following up here, what can be done, having greater communication between the ABA schools and the Cal Bar accredited schools. We're not the minor leagues, but we offer a different type of education in a smaller setting. And with oftentimes a lot more attention to special educational academic support needs. And that would be I think, a very beneficial, another pathway that could be developed.
It is to your point, I think your larger question also was, to what extent are these students impacted? And I think that there is an appreciable impact when it comes to DQ thresholds, and depending on the schools, sometimes they change the level and they increase the, so instead of having a 2.2, now you're DQ'd at a 2.5. So and sometimes those kinds of decisions can impact those students, and they are often, to your point, at a loss when they're DQ'd from, an ABA accredited school. But to be able to give them the knowledge of what your options are, and just the inspiration, because I think they just feel so dejected at a certain point. But to let them know that they can actually complete law school and take a different route, I think is really helpful to the students in counseling them on their way out of the institution.
Yes.
Yeah, I just want to say that whenever I hear about taking the bar exam for the second or third time, I'm appalled. Just like I'm appalled when I hear about 6-year graduation for 4-year colleges. These become excuses for us not doing our jobs. Students should pass the bar exam the first time they take it. And to the extent students aren't doing that, we're failing. And to say it's second or third time, where you're just increasing cost, expense, and anxiety isn't the answer. And we're letting them down, and we're letting a system down. We did, I was talking to Leah this morning about, we did increase our academic disqualification threshold because we looked at the numbers and we said, at the end of the first year, it's pretty predictable. Okay, below a certain GPA, they're not going to pass the bar exam on the first time, and it's unlikely they'll pass on the second time, and why should they stick around and incur 2 more years of debt? Now, to the extent that there was concern that might have a disparate impact, we looked at the numbers, we didn't see that yet because the numbers have been so small, but in that situation, the faculty gave discretion to the dean's office to look at that, and if there were, is to alleviate that. So I think that's really important to address that issue. But this gets to the broader issue. I want to get to the issue of what can we do about it. Can I just a couple of points, because I've been a dean for 8 years, and one of the first years I was in, I went to a national conference about this issue by the group that's law firms and corporate legal departments about access. And one of the things I heard there from a very the dean then of Howard Law School, but the importance about when you set up these programs, and we were in the early stages of doing it, is there can't be a stigma around the programs. Okay, and so that's one of the things we've done. We have an academic success program, which is now 3 full-time people. And everybody's encouraged to take advantage of that program. It's focused on certain students and so forth. But it was important to really build that to make sure that everybody took advantage of it who wanted to take advantage of it, and that no one felt that if I go into that office, okay, that somehow there's something wrong with me. I'm a second. So I think that's very, very important. And that's something we really emphasized. I could go into how we do that. The second thing that we've done, and I think it's been really, really critical, is engaging the affinity groups and getting them actively engaged in supporting one another and developing their own programs and their own support network. Now, there's variability year to year depending upon leadership, but that's something where I put a lot more resources, and I've made it clear to those affinity groups, to the extent that they get organized and they do things, frankly, they go directly to my discretionary budget. And I'll support any initiative. They've, particularly our Balsa group, the programs that they've set up in terms of mentoring and reaching out to the community and all kinds of things are really quite remarkable. But a third point I want to make, and again, this comes from experience, and it's been my observation, and now I'm hearing it more and more from the affinity groups. I just met with them, the leaders of those groups 2 weeks ago, is they're seeing a real divide within their own groups, okay? And they are increasingly focused on those in their groups who are first generation. They have more in common, okay? It's one of the things that's more and more evident to me is the cultural gap among our students and their ability to deal with all the things that come with law school and entering into legal profession and getting those first jobs and so forth. There is this gap between those who come from professional families. You know, my daughter's in law school, mommy and daddy are both lawyers. Daddy's even a law school dean. And those other students who've never met a lawyer, don't have a lawyer in their family, have no experience whatsoever, the etiquette and so forth. Those are the ones who are most, I see, and our students are the ones who are most at risk in law school. And we need to reach out. So that crosses most of them are diversity students, okay? But they're seeing within themselves, and so what's happening in the affinity groups is they're increasingly focused on doing joint programs that are focused more on the first generational students among them, and the ones who are more so I think there are many different ways of slicing this, but we need to understand that that's a lot of where the disadvantage, and address it and engage the students and addressing that.
Can I just very quickly, I'm sorry, so to your third point about the gaps, so in my orientation, because I noticed the same thing, you got this social opportunity gaps, the justice gaps, et cetera, I do a whole segment called corridor competence, and it is directly designed to address those kinds of issues. How do you navigate these academic corridors? What is the social etiquette? You know, do you know how to eat from the left and drink from the right? The kinds of things that will be, I see people looking at slave dragons and it's the mosquitoes that really get you. So the kinds of things that will be dispositive as to their success, because they've got the fundamental native intelligence, they just don't have that wraparound exposure. So I think it is definitely absolutely critical, true point.
What school are you from, sir? I wasn't.
University of San Diego.
Oh, okay. Let me ask you about you talked about an idea that weeding them out early saves them money. And why spend them around, why keep them around in law school if they're not going to be able to pass the bar first time around, or even second time around, or third time around? Does it concern you that you may be weeding out really, really good lawyers, even if it does take them 3 times to pass the bar exam? And I'm gonna, and I ask because sometimes particularly students of color have other things going on that may not allow them even to devote the time needed to be at the top of the class. But it doesn't mean that they don't have the smarts to pass the bar. Even taking the bar exam, there may be challenges, financial challenges, family challenges. Maybe they don't pass it the first time around. Some of the smartest judges I know did not pass the bar first time around. And so I worry about how it is, and to share my own story and stuff. I had a kid when I was in high school. And I was 16 years old when I had my child. I went straight through and everything, but I graduated, it was less than 2 years old when I graduated in 1972 and stuff. Went to Cal undergrad with my kid. I'd take him on the bus, I'd drop him off at daycare, I'd go to class and everything. But I wasn't at the top of the class because I had other responsibilities. And went on into Bolt and everything. I graduated both on time, passed the bar the first time. But I will say that sometimes when we kind of look at, wow, this person really isn't going to make it. I was never on disciplinary probation or anything of the sort. I was passing classes. But I was taking care of a kid as well, and trying to figure out sometimes how was I going to pay my rent and all other kinds of things as well. Had some good family support. But it troubles me that we may well be weeding out people who have a lot to contribute to the legal profession because we've determined that, all right, they're not shining right now. And so what if it takes them 2 times? So what if it takes them 3 times to pass the bar? One of the judges, I think, has a father who took the bar 26 times before the father finally passed the bar. But I just, I don't know what we can do about it. I know that for COAF, we used to talk about how important the rankings were, the U.S. News and World Reports, all those kinds of things, and how the focus on that may mean that we aren't getting enough attorneys of color into the legal profession. So if the concern is just it's going to make our stats look bad, then maybe we need to kind of rethink those kinds of things.
This is not being driven by the stats. First of all, we shouldn't be admitting people that we don't think can pass the bar exam on the first time. Okay, so I don't think we're doing them a service. Number two is this comes with having built up support services that start with orientation and start in the first semester and bring in certain students that seem to be less prepared in terms of credentials and other things, and then making sure that some of those, interestingly, we have great success with those people, academic success that first semester in terms of ultimately bar passage, even though they're the ones with the weakest credentials. Okay, and then other people get involved. I'm not talking about large numbers. I'm talking about going from maybe 1 to 2%. I mean, we're talking about a handful of students a year. It's not a lot. It's really not a lot of people. And so we're not talking about vast numbers. I also say we haven't seen a disparate impact yet. But another thing is, I'm sorry, we need to fix the bar exam in California. It is too high. The problem is not what law schools are doing. It's the problem of the bar exam. There is absolutely no reason why people who can be qualified to practice law in every other state in the United States, none of which is as diverse as California, are flunking at the rate they are in California. That is unacceptable. It's immoral. Okay? And just to say we're going to continue to capitulate and let people fall victim to that process and put them to 3 or 4 years after law school getting more and more in debt and more psychologically burdened, because who's going to give them financial aid during those years is just to capitulate to a system. So I'm doing my best to change the cut score. I'm doing my best to make sure we don't admit people who can't pass and we support people. But in the end, I can't, and it's not because of the rankings, I cannot morally justify keeping a student on who we've given every chance to at really a relatively low threshold that I don't see the prospect that person can succeed in the profession. I think it's immoral to keep that person on in law school. I don't care who that person is.
Yeah. Brenda, getting to the third bullet point, what can the State Bar do to support programs, and getting to sort of some of the things that have been said here, I think that taking from your story and the San Diego Dean's story, I know from personal experience that, especially for first generation people, I don't care what color you are, you could be from Appalachia, be first generation, the mentoring makes a difference. Yes. I get phone calls from young women at Hastings who are asking me if they should stay and finish the semester because their mother in LA, who doesn't speak English, has just been diagnosed with cancer. And the fact that the student will call me, and the fact that someone can be available to the students that the dean from San Diego is talking about, to talk to them one-on-one, as Elizabeth said, if they know you care about them.
Yeah.
So I have a very crazy idea, Leah. How about if we give MCLE units? How about if we give MCLE units for mentoring? We have talked about mentoring for years. Haven't we talked about mentoring till the cows come home? And we're talking about the affinity groups. And I know what you're talking about. And I know we've talked about this ad nauseum. And I don't know why wouldn't the State Bar, with the mission that it has been given, what else? The continuing legal education. Why don't we see, I mean, it's just a thought, Leah. Let's see if maybe some of these affinity...
We'll take that back to the co-op.
Let's talk about that June 7th.
We'll try to discuss it at the next Council on Access and Fairness meeting.
Just if I could ask the schools, because I think one of the questions I have is how much of this is anecdotal and how much of it is data supported, meaning for your attrition rates that you have, can you quantify why your students are leaving? Like we could look and say, for the last 5 years, we've done exit interviews, or I know this group we've asked to leave for academic reasons. This group has left because they got their loans, their grants, or their scholarships pulled. This group has left because of personal reasons.
All of the above.
But do you have the actual information? And you keep the stuff, all of you keep it.
Okay. And then perhaps then we can try to drill down and see where can we, but it looks like it needs support in all of those areas, and particularly the financial support. I think unfortunately, I'm told that we have to stop. Shoot, I'm gonna stop. I'm sorry. Okay, all right.
You're the judge, keep going.
And I thank all of you for your input, and I want to welcome you. This is really, really wonderful. But I guess I have to exit stage left here now.
No, I didn't say that.
But I would really encourage you to continue the conversation and just share your ideas and suggestions, either with myself or Elizabeth Hom or with admissions, because this is a conversation. We want to take these recommendations to COAF to then make recommendations to the Board of Trustees. And so this is asking from you, what is it you think the State Bar can do in order to support these students? And so it is presenting these ideas because you are the experts in your fields.
Yeah, and sometimes you think this shouldn't be a law school problem, but unfortunately it is these days. You know, reading about high schools who are putting like laundromats in their schools because kids didn't want to come to school, high school, junior high, because their clothes were dirty, and they were. I grew up in extreme poverty myself, but it's kind of like they're ashamed, and they didn't want to come to school, so they were dropping out of class. So they started putting washers and dryers in the schools, and so kids would come, they'd wash their clothes, they'd go to class, and so sometimes we have to think outside of the box. Because of social problems. No, they're not of our making, but the reality is we have to reach out to try to see what we can do to support our young people. Yes?
Can I just add one more suggestion, and it's related to what Stephen was talking about. What I found over the years with the affinity groups is the stuff that comes from the students is much more successful than it comes from top down. If the State Bar affinity groups can reach out to the affinity groups at each of the schools to listen and hear what they need and what they want, that's probably going to be more successful than anything else that you could probably.
This is a great lead into our next section.
Yeah, I mean, this was something that was going through my head when Dean Brolin was talking. So you've been talking about your affinity groups, your affinity associations in your school. Have any of you established relationships with the local affinity bars and have sort of work with them to establish mentoring programs for the students? Is that sort of a relationship building that the State Bar could help you all do to establish those relationships maybe and create some of those mentoring opportunities?
I think if it comes from you guys to them, it'd be more successful. Just because, we can drive whatever we want, but it depends on the leadership of the student groups at the time on how successful they are. And sometimes they just don't know. And I think it's helpful if there's people on the outside that are reaching.
I think we've had a summit with just about 30 or so folks from the various affinity groups. We met with folks back in August, and they all talked about mentoring that they did. But I think the mentoring that they were talking about was of young lawyers, not of law students. And so this really might be another avenue to get them interested in and excited. Again, one of our strategic plan goal objectives is to identify the support that we can provide to all of you to help address this retention issue. And so any more of these ideas, as Helen said, keep them flowing. But I think sort of putting together what Catalina said, this issue with the affinity bar associations, I'm certainly seeing some opportunities here. So this is very exciting.
Well, real quickly, we are in Santa Rosa creating a roster of our alumni members who have all agreed now to put their data, a brief bio on how they were situated during law school. And these are going to be for mentoring applicants even, who are having difficulty deciding whether to go. So it's going to be for applicants, current students, brand new graduates. They're willing to help all three stages. So that's another thing to, if you have a good, strong alumni group, to keep in mind.
Right. But we don't want to be rude.
No, thank you. Thank you to Elizabeth and a sign of a good discussion is that I had to cut him off.
Yes. Yes. Thank you. So this was a great segue in terms of asking about student input. One of the other, under our fourth goal, increasing access to justice. As many of you know, the State Bar provides nearly $50 million in IOLTA revenue in grants for legal aid organizations. However, we also know that the unmet need is much greater than the resources the resources that we have. And so one of the things that California State Bar is doing is actually measuring what is the justice gap in California. How does that differ by geographic location versus rural versus urban, as well as population in terms of being a senior citizen, a veteran, a woman with children, or special types of legal needs, in order to address how we can be more thoughtful about how we support and decrease the gap in access to justice. So along with that, one of the questions that the Board of Trustees has is whether or not the cost of law school impacts the ability for students to pursue legal aid public interest programming. Coming from someone who, one, had to drop out of law school in order to support my parents to run the store because no one else could when they were sick. Took me 2 law schools in order to finish. And it was only because I used my student loans in order to buy a condo that I could pursue my career in legal aid. I know that people have to make hard choices even though they want to pursue the work that they love. And so with that, the State Bar is modeling our Justice Gap study along with the Legal Services Corporation study that came out 2 years ago, commissioned by NORC in the University of Chicago. Measuring not only what the legal need is, usually it's measured by when someone has to go already to legal aid, versus what are problems that they have that have a legal remedy, along with a survey with our legal aid programs in terms of who are they able to serve and unable to serve because of funding restrictions or of their own capacity. Along that, we are also looking to see what students have to say about their experience. And I know that you received a survey about asking about your loan repayment programs at your respective schools, because one of the questions is whether or not a loan repayment program through the State Bar would, in fact, increase access to justice throughout the state. So with that, I'm going to introduce Alina Copeland, who is the Executive Director of the Legal Aid Association of California, to talk about our work together.
Sure, so I have a smattering of different things to discuss today, but I do want to say, since Helen brought it up, I actually used my student loans about 15 years ago to buy a car, which I still drive today, because otherwise I couldn't afford it. So it was a very smart idea to buy a Toyota. What Helen mentioned about the Justice Gap study, it's really interesting that nationally the Legal Services Corporation, which is the largest single funder of civil legal aid across the country, they've done this Justice Gap study every couple of years, or I think it's 5 years perhaps, and they get really amazing data nationally that we use all the time with national partners, with funders, to talk about what are the civil legal needs of low-income Americans and low-income residents in states. I don't think that citizenship status makes a difference because many of it is just, are you eligible for legal services based on the civil legal problem that presents. So what's really interesting about these LSE studies is the most recent one that came out back in 2018 showed that 71% of low-income American households had at least one civil legal aid problem that they identified through questionnaires. This is not someone who said, I have a legal problem, I need a legal aid attorney. This is someone who said, this crappy thing happened to me, let me tell you about this crappy thing. And then the actual person doing the interviews coded that as, oh, that's a civil legal problem. This is a problem that actually a lawyer could have helped this person if they knew to go to legal aid. And so of the 71% of low-income households across the country who had at least one civil legal problem, there were actually a large percentage had more than one problem. So maybe you had a consumer debt issue, and you had a medical debt issue, and you also had a child custody issue, and you had Maybe you're trying to figure out if you need to get a restraining order to protect your family from violence. So there's all these issues that can actually convene in one household because problems, add on to each other. And of those people who had a civil legal problem, roughly 86% did not get the help that they needed. So people have bad things that happen all the time, and actually our legal system can help them if they know that bad thing has a legal solution, and they know to go to legal aid, or they know to Google to know where to go, and they also go to a location that has adequate resources and trained attorneys to serve them. And so the piece that we really focus on at my organization is making sure that there's good outreach, that people know they need to go to legal aid, and then once they get to legal aid organization, my organization, which is an association, works to increase resources, so more legal aid attorneys. We work to have really great training, so better trained legal aid attorneys. We partner with the State Bar and with the Judicial Council all the time on trainings. And we also work to make sure that organizations are talking to each other, and that if you are a legal aid attorney in a 2-attorney office in Lake County, that you know to reach out to your friends across the state and say, I have this weird legal issue, is there anyone there who has some briefings that they can share with me, or can I consult with someone to help me out in this case, because this is not something I've seen in my practice area. So of the organizations that the State Bar actually funds, there are almost 100 organizations. Some of them are very tiny offices, and some of them are quite large with over 100 attorneys. And my organization works to connect them all so that they all support each other. And so the reason why we were very interested in seeing to increase that pipeline to civil legal aid and increase that pipeline to nonprofit work is that right now, as Helen mentioned, the State Bar actually gives out a lot of funding and grants to legal aid organizations. Our legislature is actually doing a fantastic job of increasing state funding for legal aid. And so we want to make sure that the students who go to your schools know there are jobs now. When I graduated, there were not jobs. There were just no legal aid jobs available a decade and 2 decades ago because the funding was so tight. And I knew people who actually had their offers rescinded because the organizations had their funding cut. But we're in a very different world now. There is funding for legal aid, and so when your students are thinking about their summer fellowships and their postgraduate fellowships and what are they going to do when they graduate and where can they do some pro bono work, civil legal aid is a fantastic resource. And so we're looking to figure out how to open up that pipeline. So the Justice Gap Study has some really interesting pieces where just for California, we're going to ask those national questions. When that crummy thing happens to you, tell me about that crummy thing, and the person on the phone will code it as a civil legal issue. And we're going to be able to find out where in the states are there certain legal issues which our policymakers would love to hear about, to know the regional issues that are just popping up, and is that an issue that could be addressed through policy work, through advocacy, through changes in the law. And we're also going to be looking to see, where's there a larger need for legal services? It's perhaps the case that maybe there are some regions that are particularly underserved because there aren't enough civil legal aid attorneys there. I've done a few presentations to State Bar Board of Trustees about the crisis of access to justice in rural California. I'm the co-chair of the California Commission Access to Justice Rural Task Force, and you can't tell me that my accent has gone, but I'm originally from the Texas-Arkansas border. And so the rural pieces are really important to me because I know what it means to grow up in an area where you don't have access to an attorney, and the only attorney there is a retired attorney who just takes on, takes on wills and trust cases. So we're really trying to look at, are there regional differences in the access to justice needs of our low-income Californians? And so back to the pipeline issue, we want to know how law students make their career choices. How can we influence those choices by letting them know there are other jobs available, letting them know that actually as a civil legal aid attorney, you may get some trial experience. You're actually going to be in a courtroom. You're going to be able to work closely with a supervising attorney and get time that you wouldn't get if you went to larger law firms and were kind of trapped in that doc review for several years. So we're really trying to find out from law students, what is your perception of a career in a private law firm? What's your perception of a career in government work, in civil legal aid, or in other nonprofit work? We're going to be actually, at some point this summer, issuing a law student survey that we would love to have you send to your students. And at some point in time, I'm going to ask you what is the best time to send that survey, because we would love to capture some of the people who are exiting, and maybe they're just on email because they're studying for the bar exam anyway. But we do want to capture people who are exiting now, and then also perhaps look again in 2 years' time to see how things shift. I'll talk quickly, but I've heard anecdotally from enough people to worry that this is a real trend, that the insecurity of the federal public service loan forgiveness program is meaning that this generation of the students in your schools now are not as willing to gamble and go into a career in legal aid. I graduated before public service loan forgiveness program, so for my generation of law school students, it was either your school had an LRAP or it didn't, and that was it. Or you could go to the federal public defender program, the justice program, our justice program. But for civil legal aid, your school had it or you didn't, and that was it. But now, students now know that they may be eligible for public service loan forgiveness program, or maybe not. And so we really want to talk with students to see, are you willing to take that gamble knowing your current law school debt? You're all aware of your law school debt figures for your students who are graduating, and we want to know, does that make a difference? We all suspect it does, but we want to actually look at the data because we can't just make policy decisions and we can't make changes. We can't create an LRAP program. We can't do any of this unless we have actual data to support it. So we want to find out from your students what would change their minds. If it's a case that their law school doesn't have a fully funded LRAP program, what if the state put some money in for LRAP? Would that make a difference? How much money would make a difference? My school had LRAP, and so that's why I'm still in legal aid now, nearly 13 years later. But not every school does, and some schools have an LRAP program that's partially funded or maybe competitive, and we want to find out how does that affect a student's decision to take a gamble and go to legal aid. I think I hit all the marks.
Yes. So first question is, if we want it, it's a short questionnaire. The survey will be probably less than 15 questions. It really is about career choice and impact, if at all, based on law school debt. Best time to send out the survey? June?
Not now.
No. June? July?
No.
August?
April.
We can't go backwards.
March sounds good to me. I mean, that's in between things. It's not a lot happening right there. It's if the people who are getting toward the end of their career in law school some of them already have an idea of where they're headed and why. And if you're talking about third year or in our situation, third year is next to last year, so you're maybe the second for the ABA schools. They also have an idea of where they're headed and what their choices are like. So March might be a good month. There's not a lot of finals. There's not a lot of other things that are going to take their time.
If you're trying to capture this year,
yes,
it's almost too late because you could try sending it out in August, but at that point, people are focused on they finished the bar, they're going forward.
Yep.
You might not get a very good response.
We do want to have all 3 years though, first, second, and third years, to see how that perception changes throughout the years as well. And so that's part of it. The second part is we also want to supplement it with focus groups that Selena would be conducting at both rural and urban ABA non-Cal accredited schools to actually talk to the students as well. I forgot that part. So if you are interested in hosting and having us come out, please let us know. You can email me because we would like to have about 8 to 12 different focus groups talking with students. The other part of this is that we're looking at recruitment and retention in legal services. When we talk about CAPA, talking about the skills, right? We know that a lot of this is skill development. Our data has shown that there is a huge attrition in legal aid attorneys around years 3 to 4, right? So you build the capacity, you train, and they normally go to the government. And so we're also trying to see that impacts our pipeline for skilled attorneys and supervisors. So could this LRAP then support retention in order to look at access to justice? And so these are the kinds of questions that the Justice Gap Study is going to be looking at. Not only the legal need, looking at recruitment and retention within legal services and pipeline for law students and the impact of law school debt and whether or not the State Bar can make recommendations and changes or other means to support students to engage in access to justice work. Thoughts, comments, besides the fact that I can't go back in time to release the study? Survey?
Yeah, I mean, just to clarify, the Justice Gap Study is due to be completed
the end of this calendar year. So that sort of phone survey that Selena and Helen had talked about with people to find out what kind of problems they have, the intake census at legal aid organizations to see who has shown up and has been turned away, and also this law school component. So we are looking for the opportunity to do that survey and the focus groups sometime from now going forward before the end of the year, in time for us to get the results and incorporate those with the other pieces of the study. And I think my intention too, to build on what Donna was saying, is that we would love to do this survey every few years, because I think there will be federal policy changes that may, hopefully at some point in time, improve the stability of the federal public loan forgiveness program. And I hope to see a change and more people willing to take a gamble on a career in legal aid if they are more sure that their loans will be forgiven after 10 years.
Let's not take a gamble on our this.
Would you all be in a position to help us distribute the survey to your students? Sure.
Do it in
Thank
the
you.
fall, do it in September.
I was gonna say September is the best month.
September.
Okay, excellent, excellent.
I'm an old legal aid lawyer myself, not long ago. I think, that wasn't the issue for me in retention, but I think two issues you're going to encounter are salaries, especially with people that are wanting to form families and families and move forward. And also, I think people really don't get the training they need to feel like they're advancing professionally.
Yeah, actually Florida did a survey, it was a recruitment retention survey, I think back in 2007, of civil legal aid attorneys in the entire state of Florida. And I love that one because the title of that report is, "It's the Salary, Stupid." And that's why we lose people, and I think that's honestly still a concern everywhere, especially in the Bay Area, where you would also like to be able to afford rent.
What's your email address?
It's Helen with 2 L's, HELLEN.Hong, HONG, at calbar.ca.gov.
Thank you.
Yes.
It seems like it would be really powerful if you could also track some of the prospective applicants that are on their way in terms of their potential career interest in doing public interest work, and then coupling that on the back end with the drop-off and the salary stupid idea, if that in fact is what you see.
That's why I think it'd be great to do it in September, because you get the new law students who just come in, many of which we see with the current upswing are people who are really interested in that area. So they eyes are wide open. And then in the course of law school, they start to realize some of the economics. I think that'd be a good time to do it, because it's early enough they'd still have those insights. I would suggest you do it in September. We can certainly help do that.
And we're also exploring the idea of launching something with the through the California Young Lawyers Association, right? Sort of to follow that theme that now they've gotten out of law school and they're really faced with that debt and what is happening.
Yeah, I was just wondering if it may be helpful to you if you can talk to the law school's survey of student engagement that most schools participate in. There's similar types of questions that are asked in there. I don't know if they make that available to outsiders of the aggregate, Stephen, or if it's, we all have it, if we did it, we have it internally, what the results of those are. That I'd be happy to share from my school, and I'm sure other deans would too. But what I've seen is the big interest in public interest when they walk in, and then at the end, it falls off. I mean, there's a huge drop. And those are the types of questions that they ask. They don't ask whether or not the finance questions that you're asking, but there might be something in there that might be helpful to you.
So the Justice Gap Study will also look at research that the Office of Research and Institutional Advancement is looking at. A lot of that is a lit review about how scholarships actually, even with the same amount of money from a law school, make a much stronger impact in career choice than loan repayment. Even with the same dollars, and also about the socialization within law school, the competitive nature, and within OCI, that yes, you can have a competitive, you can be wanting to do public interest, but when everyone's interviewing and doing 20 law firm fancy dinners, it's hard to still say like, okay, I want to take this battle of poverty for the rest of my life. And so that's very helpful. I really appreciate it. I want to make time because we're going to move on to the bar stories and strategies. Elizabeth Hom, who's in the back, had sent out a request about loan repayment programs at your individual schools. If you were not able to fill that out, or you have additional information, can you, we have sheets so that, or, yes, and so Natalie will follow up with that. If you have additional information about your LRAP programs, because we want to see the difference. from a legal aid perspective, your LRAP funding from schools is not taxable. When an employer pays for it, it's taxed, so it actually hurts us at the end when we're paying our taxes. And so it doesn't really make a difference sometimes. And so we're looking at that kind of nuanced information in order to advise the board of trustees.
Can I add one thing?
Yes.
The only one thing I want to add is we plan to ask, we're still finalizing the questions now, working with the bar. We plan to ask, when you entered law school, what was your intended career choice? And list the public interests, government, private firm, academics, and then say, what's your current career plans? And if you changed it, why did you change it? And list a host of reasons where they can just click and then give an other, because we want to see why do people change, because many times it may just be a personal reason. People may need to have, not that they want to go to a large firm and make a lot of money because they love to make money, but they have family commitments and they have legitimate financial concerns. And so I don't want to actually discredit that. So I want to make sure we ask all the right questions and find out the why, and then see what would actually make a difference. So, thank you.
Thank you.
So our final presentation of the day will involve the BAR Strategies and Stories program, originally called the Productive Mindset Intervention Program. We've brought some of the study designers, Dr. Victor Quintanilla and Dr. Mary Murphy, here to talk about the program and how your students can still get involved in the next session, which will be part of studying for the July 2019 bar exam. And just to let you know up front, they will be making a quick time out the door at the end of the presentation at 3 p.m. because they do have a flight to catch. They were very excited to have this audience with you, and I will be happy to share any follow-up questions with them.
All right, good afternoon. My name is Mary Murphy. This is Victor
My name is Victor Quintanilla, and I'm a professor at Indiana University and the co-director of the Center for Law, Society, and Culture.
And I'm in the psychology department. This is a project that we are really excited to share with you. We designed a psychological intervention designed to promote success on the California bar. To tell you a little bit about the background, this is our team. We are scholars in law, sociology, and psychology from a host of schools, Indiana University, USC, Stanford, Wake Forest, and UCLA. To tell you a little bit about what we're going to do in our 30-minute block, we're going to talk a little to frame this out for those who had not seen us a couple of years ago when we were here, a little bit about what psychological friction is and how we actually addressed psychological friction in the intervention that we designed. We're going to tell you a little bit about what we learned through the surveys and focus groups that we conducted in 2017, and how we use that information to then design and then later evaluate the effectiveness of this intervention in 2018. And then we're also going to share with you some interesting additional predictors that came out of this research that I think you as deans would be interested to know. So we know that students contend with psychological friction, both in the law school setting and also on the journey to bar passage. The way that psychological friction often shows up for students is feeling that one doesn't belong, whether that be academically, culturally, or socially, experiencing doubts about one's potential, having maladaptive theories of stress, which we'll get into in a moment, and also endorsing fixed mindset beliefs about their own ability. I either have this ability or I don't. It's something I can change or not change very much. And so what we did was that in 2017, we partnered with the State Bar of California to gather data regarding student experience of psychological friction when preparing for the bar exam. And we wanted to use that to design and evaluate an intervention for the 2018 cohort. And this would aim to alleviate some of that friction that we saw just a moment ago, tamping down stress, freeing up executive resources to allow students to perform at their potential on the bar exam. In June 2017, we conducted surveys with law school graduates who sat for the July 2017 California bar exam. And so what we did with these students was we invited them in to USC is where we conducted the focus groups. And we had students from all around the LA area, 5 different law schools represented. And we invited them in and surveyed recent law school grads about these kinds of psychological issues, their mindset beliefs about bar exam performance and other areas of psychological friction, their studying behaviors, what they were actually doing on a day-to-day basis in order to prepare for the bar, and variation in that, their sense of self-efficacy for passing the bar, and their confidence in their likelihood of passing. One of the things that emerged from these surveys significantly was overwhelmingly growth mindset beliefs about the bar exam were the biggest predictors of a host of psychological and performance outcomes. So growth mindset beliefs about the bar exam, this is too small to read, but a question that measured this was, your test-taking ability is something about you that you can change substantially. So it's this belief that I have this set ability and I can change it, I can develop it, I can expand it through hard work, efforts, different strategies, asking for help, these sorts of strategies. And what we saw in that survey was that these growth mindset beliefs about the bar predicted the kinds of positive psychological experiences you'd want to see students entering the bar exam with. They believed they had greater potential to succeed on the bar, that they were more capable of meeting the demands of the bar, more capable of handling stress during the study period, and actually engaged in more effective emotion regulation strategies during that study period. We also found that growth mindset beliefs about the bar decreased some of the negative stuff that you would not want students to go into the bar exam with. So it decreased their sense of pluralistic ignorance, which is that I'm the only one struggling, I'm the only one under stress, I'm the only one really contending with the issues that I'm contending with during this particularly critical moment. It also reduced their stress in this period of time, and also reduced their scores on a depression inventory, as well as their sense of loneliness. We also found that growth mindset beliefs were related to self-efficacy and confidence about passing the bar. And if you think that these growth mindset beliefs are just sort of all rainbows and sunshine, and maybe it actually causes students to sort of take their foot off the pedal when they are studying, we actually didn't find evidence of that kind of thing at all. Growth mindset beliefs, for example, were not predictive of whether or not students thought the bar was important, how demanding the bar was, or the amount of time spent studying for the bar. So we found that both fixed and growth mindset students reported these things equally. So we then used that survey to conduct some focus groups. And these focus groups happened in December of 2017, after that cohort of students had sat for the bar in 2017 in July. And what we noticed from the focus groups were 3 areas of psychological friction. The first one was those limited fixed mindset beliefs about their ability and the maladaptive behavior that came from it. So if I believe that I have a certain level of ability, I can't do much to change it, and I start to make mistakes, I actually don't double down and review that material when it comes to those mistakes, because I kind of feel like, well, that's just not my area, right? That's just not an area that I'm going to excel in on the bar. I'll focus on the other areas where I'm better at it, right? We also saw stress as a huge factor of psychological friction. And the stress came from many different points of friction. The fear of failure, the time constraints, obviously, the amount of information to memorize, and negative feedback when studying. And then we heard over and over that students were stressing about the stress. They would feel their heart rate go up, they would actually start to get sweaty palms, right? And they would stress about what that meant for their ability to encode and remember and retrieve information while studying. And then lastly, we saw over many of these focus groups that students were reporting significant flagging motivation, particularly when it came that middle period, right, when the test was maybe 2 or 3 weeks away, and they had trouble persisting at the same level of studying and attention to the material that they needed to process. So I'm going to go a little bit into detail about what these are, because you're going to see how we actually address them in the intervention, and then we're going to share the results of the intervention with you as well. So this first area of fixed mindset beliefs, as I said, mindset beliefs are just people's beliefs about the malleability of human characteristics like intelligence or ability. Those who endorse these fixed mindset beliefs think that there's a potential that can't be changed. You either have it or you don't. I'm either good at taking tests or I'm not. I'm good at studying these materials, or I'm good at contracts, or I'm not, right? Growth mindset beliefs are the belief that intelligence and ability is malleable and that it's a potential that can improve with effort, motivation, and learning. It's something that can be grown and developed. What we know from many, many studies and meta-analyses is that students can interpret mistakes, which we know that all students are likely to make, especially at the beginning of their bar prep courses where they take those initial tests and they get horrible results, right? And that's the point of taking those initial tests when they first enter into these bar prep courses, to be able to show improvement over time. But students can interpret these mistakes as a sign that they've reached the limits of their ability if they endorse these fixed mindset beliefs. And this is especially problematic when students are studying for high stakes exams, right? When it really is the pressure's on, and the fixed mindset will cause students, instead of doubling down in their motivation, they actually will take their foot off the brake when it comes to motivation, because it's noxious. It makes me feel as though maybe I just don't have what it takes to do well. The growth mindset, on the other hand, we know boosts motivation and performance. This is simply the belief that these kinds of characteristics are developed and expanded with effort. And we know that when students come to exams with this growth mindset, it enhances their motivation to persist while studying, and it boosts their ultimate performance on high-stakes exams, like standardized tests. The second area of psychological friction that we noticed in those focus groups and in the surveys were students' stress mindset theories. So students, we sort of noticed, were in two different camps. Some students really believe that stress is debilitating and should be avoided at all costs, right? And so they had this belief that stress undermines motivation and performance, and thus they would be very stressed about the stress that they were experiencing. And we know from other studies that having that kind of maladaptive stress theory undermines performance on high-stakes exams. The other belief that we saw coming from students that seemed to be facilitative of their motivation and performance was the belief that stress is actually necessary and actually facilitating of attention and performance. And we know from studies that this improves motivation, learning, and performance, particularly when stress is high. To have that kind of adaptive stress belief, stress theory, is useful for students in moments of stress. So one of the things we wanted to do, looking at some of the interventions that have been done with students, is just to sort of show students the science of stress. This is the Yerkes-Dodson curve, which shows that actually as stress gets higher, it does have this attention-focusing component to it, where people can actually encode information better, and that a certain amount of stress is important for optimal performance on exams. The third area of psychological friction, and the last one, was that flagging motivation that we noticed among students, particularly sort of in the middle, the doldrums of studying for the bar exam. And we went to the psychological research to say, how have people re-engaged motivation when motivation is flagging? And one of the most effective ways is asking students to reflect on and renew their sense of purpose for why they're actually sitting for the bar exam. And we know that this re-engages motivation, it enhances attention. What you're seeing here in the right-hand side, which is pretty small, is that to the extent that students endorse more of a purpose for learning, what their purpose is, and reminding themselves of their purpose, the more likely they are to persist in college. So we took this kind of example and we thought, okay, let's see if one of the things we could add to the intervention is asking students to remind themselves of the purpose for why they are sitting for the bar. What we know is that fixed mindsets about mistakes, maladaptive theories of stress, and a lack of purpose increase threat processing in the brain. So there have been several neuroscience studies on each of these different kinds of components that show that the amygdala is really activated in contexts where these mindsets, these maladaptive mindsets, are present. When we can change people's mindsets to be more of these productive mindsets, we know that the amygdala is reduced in terms of its level of activation, and instead we get blood flow to the ventral medial prefrontal cortex, where really sort of our thinking brain, our mentalizing, focus kind of part of our brain is turned on, which allows for better encoding and retrieval of information. So our theory was this. Coming out of the focus groups and the surveys, we had this theory, social psychological friction affects bar exam performance, such that at the late spring semester, the 3L year before graduation, students might have had certain challenges in law school that already made them sort of worried about their sense of belonging or their potential for the exam. Then they're starting to register for the exam and really take in, the high stakes nature of it. And if one addresses this high stakes nature of the exam through the fixed mindset beliefs, for example, on those early tests that they have to take, the practice exams, and they make a lot of mistakes, that's going to increase their worries about potential. They're going to stress about the stress that those mistakes bring, and then they're going to encounter this flagging motivation to persist. And all of this sort of is a downward spiral when it comes to sense of potential and belonging. So we worked with the bar to create the 2018 California Bar Strategies and Stories program from understanding the psychological processes that students are contending with in a real sort of bottom-up way. We do want to acknowledge our partners in this. AccessLex provided the funds to support this research, and Leslie provided some of the data that we're going to show you as well. So here's what we actually did. In March of 2018, an email was sent to students who were registering for the bar exam. And they received an initial survey invitation to opt in to receive this program in May, right after graduation and right before the test prep courses began for the bar exam. Okay? So they get to opt in, they provide consent. This is IRB approved, so they have to go through the IRB approval consent forms, which are pretty brief. That happens in March. Then in May, immediately after graduation, and again before those bar prep courses have begun, the intervention was delivered online as students are beginning their studying process. So we designed the intervention program, the Stories and Strategies program, for U.S. law graduates who are preparing for the California bar exam. This leaves out several groups that we will return to later, but really we were looking at first-time test takers who graduated from U.S. law schools, your students, really. We had applicants opt in, as I said before, when registering for the bar exam in March. Test takers consented to participate, and we collected their demographic information then. There's a lot of evidence to suggest you don't want to collect demographic information right before you sort of give them a program like this to avoid the stigma that might be suggested. And also we wanted to use this information to randomize, if this is a stratified random assignment, to randomize students based on these characteristics. So we would have equal numbers of women in the treatment and the control group, and of men, and of people of color of different race and ethnicities. Of first-generation college students, we wanted to have equal numbers in the treatment and in the control group. So we do that through a stratified random assignment. We needed that information early, and then we run a machine learning program that puts them into different treatment and control groups so that that's equally done through stratified random assignment. Then in May of 2018, they received links to the actual program, which is a 45-minute program that was delivered online. And we're going to show you what the program entails. And as I said, this is a randomized controlled trial, which allows us to evaluate the causal effects of this intervention. And we considered bar performance as our primary metric of success, but you'll also see we measured several other things that we will share with you today. So again, the brief program was delivered online after graduation in May 2018. And we use this randomized controlled trial study design, which is really the gold standard method of examining efficacy of programs like this. Every test taker was randomly assigned to either be in the control condition, where they received study strategies and tips. Things like, it's important to outline after every lecture. It's important to review your outlines once a week. And these are sort of standard study strategies that we know to be effective for students. So both conditions we thought could be somewhat effective, but the treatment condition is the condition that actually addressed the psychological barriers that we had uncovered in our focus groups and in our surveys. So that was the productive mindset intervention along with study strategies. So again, just to sort of illustrate this, you might have different study populations, different groups of individuals, and we, through random assignment, put them either in the treatment or control. We did not do a follow-up this time, but actually, yeah, we sent the program later, that's right. So we did the initial intake, then we sent them the program in May, and then we compare the results. So the treatment actually consisted of 3 main messages that came from those focus groups and surveys. That mistakes are common at first, and they help us actually identify where more effort is needed. We were hearing over and over again that when people were making mistakes, they were saving that information to the very end to study because it was somewhat noxious to study. They'd rather just focus on the work where they were already doing well on, and we heard that enough and saw it as particularly worrisome that we wanted to sort of counteract that behavior and reframe mistakes as a way to actually where we should be paying more effort sooner in the process of studying. The second message of the intervention was that stress is useful rather than debilitating in order to reach peak performance. And the third was that reminding yourself about the purpose for taking the bar exam would help overcome flagging motivation. The intervention itself consists of a summary of the surveys that we had done with bar test takers to show how this was important to previous test takers' experiences and their success. And then we gave them 9 representative stories from different students. And this was recorded in an audio format, and students saw the quote as well as heard an audio of students reading their stories along these 3 different dimensions. So let me give you an example of one of the stories, and this one is really focused on mistakes. And reframing mistakes. So you click on this if you were in the intervention condition, and you'd start to hear someone read, "I'd done pretty well in law school, so I was shocked when I got my first practice test results. I mean, I wasn't expecting a perfect score, but I didn't expect to do that badly. I started to worry I'd never be able to pass. From then on, each mistake felt like a sign that I wasn't cut out for this. So I avoided those areas instead of learning from the things that I was getting wrong. Then one day over lunch, a friend who sat for the bar last year asked several of us if we'd recovered from our first practice exam yet. We looked around, and it became clear from our faces that none of us had done well, but we had each kept it to ourselves because we didn't want to look bad. Our friend smiled and shook his head. Of course your first practice exam sucked. Everyone struggles at first. That's why you're taking a class and studying. Then he said, let your mistakes show you where you need to go deeper with the material. That really resonated with me, and from then on out, I really tried to embrace the idea that success is about learning from your mistakes. Over time, I found myself learning more, doing better, and making progress. In fact, some of the subjects that I did the worst on early in the summer, like property, became some of the better ones by the end. So you see this narrative around mistakes and ways of reframing it as actually useful. A second example that I'm going to share, and this is the last example, is really around reframing stress as helpful rather than debilitating. So here someone would read, when I first started studying for the bar, I stressed a lot about everything I had to learn. Then I started stressing about being stressed, and that made it even harder to focus. I was talking to my sister about it, and she shared this amazing book called The Upside of Stress, which taught me about the science of stress. It shows how stress, the right kind and the right amounts, could really boost your performance. Stress is just your body's way of rising to meet a challenge to help you accomplish something you care about. So I tried to find ways to use my stress so it would help me study for the bar. Like when I sat down to do practice essays, I reminded myself that the excitement I felt was my body's way of keeping me focused on the important stuff and reaching my goals for the day. Don't get me wrong, I was still stressed, but now instead of stressing me out more, the stress helped me stay motivated and energized me to get into the zone. So after students saw the survey results and these stories, they then engaged in an activity called Saying is Believing, and this uses cognitive dissonance theory to suggest that when students write an essay about how this process is true for them and how it could actually help future test takers to learn this material, this actually helps students take this in a personal way, right? It actually makes it more personalized to them. This allows them to take the role of benefactors and not beneficiaries, and it's one of the ways that research has shown to reduce any kind of stigma of being the recipient of a program. And so we had students write this essay about how the process was true and it could help others, connecting the intervention message to their own experience and letting them advocate for the message around stress, mistakes, and purpose to an important audience to them, which was future test takers. And this is one of the most critical parts of the intervention, we think, from a lot of research that has been done on these interventions. Without this, it's sort of just a program that's coming at you and you don't really engage in the material in a personal way. So what are our effects? We came to the bar to do some of these analyses in December, and we have continued to explore. The first results I'm going to share are the most conservative results of the intervention. This is called intent to treat effects. Basically, this includes all participants who timely registered for the bar exam and who opted in to take part of the program. When we collected their demographics, as I told you, we randomly assigned them to condition. Now, a lot of these people never opted in, never actually entered the intervention or the program at all by clicking on the link when they were emailed those links. These analyses include all of those individuals because from an economics point of view, we want to be sure that anyone who is randomly assigned to condition, regardless of whether they even saw the content or clicked into the program, do we still see effects? That's why this is a super conservative analysis, because it includes all those people who may not have even participated whatsoever. So regardless of whether they're first-time test takers, straight out of law school, repeaters, out-of-state attorneys, or students from foreign law schools, all of those students are in here. It's 1,638 students. We control for LSAT in all of these analyses because we want to look at the effect of the intervention above and beyond LSAT. We don't want this to be confounded with LSAT, that this is just an effect for low performers or high performers on the LSAT itself. So the green is going to be pass rate, and the red is going to be fails. In the study skills control condition, the students who participated and were randomly assigned to the study skills control passed at a level of 48.1%. And the productive mindset intervention treatment increased the pass rate to 55.5%, which is an increased pass rate of 7.4%. And again, this is the most conservative analysis of this effect. We're also going to show you another effect that is often reported in these interventions, and this is called the average treatment effects. As I said, the intervention was designed for U.S. law students from U.S. law schools who were taking this test for the first time, right? And so this includes those who were taking the test for the first time, who timely registered for the bar, and who actually completed the entire program, right? So this is a smaller sample size. And what we see in the study skills control, we don't see much difference as in the studies and the intent to treat effect. Here, the pass rate is 49.8%. And here's the effect for the productive mindset treatment. We increased passage to 68% among those students for whom the intervention was designed.
I'm sorry to interrupt you, but can you give the numbers when you say it's small?
Yeah, so the number is 188 people.
For which one?
For the entire grouping. So that's how many students actually from first-time test takers from U.S. law schools, U.S. Law students who properly registered for the bar and completed the program. So the big takeaway here, so this increased pass rate by 18.2%. Now, the big takeaway here is that it really seems to matter if you complete the program and go through the whole 45 minutes, and whether you do this or not, right? I mean, what we know is that the true effect size of this program is somewhere likely in between 7.4% and 18.2%. And so what's really required to increase the confidence in these effects is to replicate the study and actually to try and increase our sample size so that we can actually explore group differences, for example, in the intervention conditions. This replication would allow us to estimate with more precision what the true effect size is. So the most conservative effect size is 7.4 increase, and I think one of the more liberal effect sizes would be 18.2%, somewhere in between there in terms of increase in pass rate.
And what was your sample for the 7.4%?
1,683. Yeah. So, yes. So I should also mention that those who actually agreed to participate and opted in to receive the program actually were students who had lower LSATs to begin with. Again, we randomized to treatment and control, so that's not confounded with our intervention. But we did see that struggling students were actually more likely to take part in the program relative to the full distribution of students who sat for the bar exam. So the fact that we see even these effects among lower performing students who have lower SAT is pretty impressive. We also found some additional predictors of bar exam performance that we think you will be interested in. Obviously, you know this very well, that LSAT and LGPA predict whether or not one is likely to pass the bar. Also, you know that repeating the bar exam relative to being a first-time test taker reduces the likelihood of passing the bar. We also found significant effects from some of the things that were discussed in the previous sessions around if a student is having to be employed in the summer or is caring for dependents while they're preparing. This also creates a vulnerability to passing the bar. And then, of course, we found demographic features of students that also are predicting their bar passage rates. If you're first generation compared to continuing gen, lower SES versus higher SES. If you're white, you have a greater probability of passing the bar than if you are black, for example. And we also see that students who contend with stereotype threat, that concern that they're going to be stereotyped or have been stereotyped in the past, that actually also creates a vulnerability, which is tied to some of these group memberships. First-gen students, low SES, and Black, Latino, and multiracial students oftentimes contend with stereotype threat. We also found significant psychological predictors of bar passage. That was anxiety, obviously, which reduced performance on the bar, self-efficacy, confidence, and also appraising the situations that would come in the course of studying as challenges to be overcome, rather than threats that were going to take me off rail, were going to derail me. Those kinds of appraisals were also positively predicting bar passage. And then you might wonder, well, what predicts these psychological outcomes that we as law deans might be able to intervene upon earlier in the law school experience? And so we explored that in some analyses. And the overwhelming predictor of having anxiety when studying for the bar, self-efficacy and confidence about passing, and beliefs about having the capacity to meet the demands of the bar was whether you felt as though you had belonged in law school. And these are items that we use to measure this. Things like, I felt like I belonged in law school. While in law school, how often, if ever, did you wonder, maybe I don't belong here? Those were huge predictors of these kinds of psychological experiences when studying for the bar. And these had significant downstream outcomes, predictor of predictive ability on whether or not students actually pass the bar. So this suggests that interventions that increase students' sense of belonging in law school might actually increase bar passage by protecting these psychological factors that are associated with bar passage. And Victor and I have been doing some belonging interventions, and several of the interventions have been published in places like Science that really deal with student sense of belonging and target the sense of belonging of students in law school earlier upstream to the process of studying for the bar. So just to wrap up here, what are we doing now? We have decided to replicate the study among July 2019 bar test takers. And as was mentioned earlier, registration for the study is still open. Students who have registered for the bar can, right immediately after they register, they're taken to a link to sign up for the Bar Strategies and Stories program. And they also get reminders if they do not sign up. They're getting multiple reminders from the bar asking them if they want to participate and opt in to receive this in May, as they're graduating. And we're working to increase the sample size. We would really like to look at, the previous theory suggests that these kinds of interventions tend to be most effective for the students struggling with the most psychological friction in these environments, and also some of the real socioeconomic and other kinds of disadvantages. So we want to be able to look at this by student demographic groups, like underrepresented backgrounds of students, but right now, again, that sample size of those who completed the program is so small that we really need to increase the sample size to do that with any kind of veracity. We're also developing a similar program for repeat test takers. We know that the psychological concerns of repeat test takers are likely to be somewhat similar, but a whole host of psychological concerns that are different, right? Because they've already failed the exam once, right? And they have a lot of these processes going on at higher levels. And so we wanted to actually customize the intervention a little bit and particularly target repeat test takers with that customization. In the next year, after we engage in the 2019 version of this program, we expect to expand to additional state bars. We've had a lot of interest from other state bars, including those who take the multi-state bar. And we're also developing, as we mentioned before, psychological interventions for delivery actually in law school to protect students' sense of belonging. Now, we would need a large cohort of law schools to really go in together on this to participate, because any law school class is going to have, many of them are going to have lower numbers of students, and we need high numbers to really look at the effectiveness of these programs. So just to conclude, before we open it up to any questions, the meanings we make of the experiences that we are having seem to shape motivation and performance. And that by arming students with a growth mindset, productive theories around stress, reminding them of their sense of purpose and securing their sense of belonging, we might be able to increase performance in high-stakes exams like the bar. So thank you very much for your time and attention. We'll take any questions.
I have a question.
Yes.
Can somebody from the state bar put up there where this happens so the law school deans can show their students how to click on it?
Oh, okay. So one of the things that we're working closely with is the PR marketing team, and they have a social media side that's been putting out some Twitters on how to do step-by-step to actually enroll in the program. Maybe that's something that they can actually send out those instructions to the law school assemblies, so then it can be made available.
It's also when students go to register for the exam.
Yes.
So they're getting it when they go to register for the exam.
We can encourage, I mean, if you,
Yeah, I thought we had sent communication out to the law schools.
We have sent communication out and will continue to do so. We had a general link in the first incident, but that allowed others who are not even law students to approach the program, and so that's why we're doing customized. But part of the follow-up that we'll do here is to give all of you more information about how you can publicize this quickly in your schools.
Yes.
When I first heard about this, and it was strategies and stories, I was wondering whether this was people who were telling stories about how to approach essays, how to approach performance tests, how to approach multiple choice questions. These are all the myths and secrets and all of that sort of thing to how to be successful on the bar examination. After this presentation, it doesn't sound like that's...
They're getting a lot of that in their bar prep, is what we discovered in our focus groups. What we really needed to do was contend with some of the negative psychology that was starting to create these negative recursive processes. That was sapping motivation, not letting them focus, and that sort of thing. So we really focused on just a different lever, which is the psychological lever here.
You might think of this as a kind of supplement. In a sense, they're getting a lot of the bar strategies from other sources, but what we're offering is a supplement to deal with some of the challenges that they'll encounter over the summer. And it seems like, right, it seems like giving them some tailwind on those challenges is giving them a boost.
Is there any thought to making this available to the students all the way along through their law school career?
We have plans of doing so. These are future plans, and so this is where we are now is in the step of creating something that seems to be quite useful for the students during the bar prep process, learning about it. There are other programs that Mary and our collaborators have done, in undergraduate and graduate programs to do interventions.
Yeah, more of the psychology that's useful in when one is beginning law school, or sort of these feelings of being an imposter in the context, low sense of belonging,
pluralistic ignorance.
So the content of the intervention would be probably slightly different, to really target versus sort of stress about stress and that sort of thing.
So are there existing intervention programs now in some context that we could refer our students to?
There are some existing, if you go to PERTS, which is the Platform for Education Research That Scales, PERTS, P-E-R-T-S. People can do a belonging intervention there, and it's mostly targeted and tested in college contexts, but we would be, our goal is to actually customize that for the law school context.
It's the kind of thing that we've learned that no matter where you are in the pipeline, there are these points of friction as you're transitioning.
Sounds all familiar for
Yes.
all the way through.
Yes. Thank you very much for having us.
So thank you, Mary and Victor, especially with being on such a tight time frame. They are actually flying to Los Angeles so that those who attend the Law School Assembly tomorrow can also benefit from this research. So thank you. I know it's been a long day. We've covered a lot of ground on behalf of the State Bar, including the Committee of the Office of Admissions, the Committee of Bar Examiners, their advisors, the CS Bars, and the Law School Council, and the Council on Access and Fairness, and of course, though I don't see her, Judge Brenda Harbin Forte. We appreciate your spending this day in conversation with the State Bar. We will be sending some follow-up to you, and we encourage that the conversation will continue. You may have ideas as you leave today or as you return with these ideas to your law school with administrators who are in other areas. So we encourage you to keep the dialogue going and to give us ideas about future programs as well. Thank you, and have a safe ride home.
Thank you.